Prova 1, 2, 3. Sì, perfetto. Vabbè.
Good afternoon to everybody, and thanks for coming here. We are happy to reach Milan with a very good weather, completely frozen, and are capable and able to participate to these 2 days. One is a workshop on hard cases. Where hard means a lot of different things, difficult to be implemented, difficult to be understood, and many different. And I will be extremely curious to understand what is under the cover of hard cases. Tomorrow we have an enlarged meeting of the project Recover, and tomorrow morning I will explain why we at the Transcrime Università Cattolica believe that this project could produce a very relevant output. I was discussing before with the representative of the Eurojust, and it was interesting about what the project could produce as an output or as a relevant output in terms of knowledge of what are the main obstacles and difficulties in implementing the regulation. And I think this is the basis for overcoming the difficulties and improving the quality of the international cooperation. For today, thanks a lot for coming. We have a tight schedule in the afternoon, and we have also an aperitif dinner on the end that should be not later than 8 o'clock in the evening. Better before. In Milan, aperitifs are 6:37. We need to organize symmetrically the good hospitality we had in Catania with the hospitality in Milan. Anna Maria.
Okay, first of all, thank you so much for coming to Milan and for your participation and on carrying on our project. Thank you so much for the questionnaire. We received the questionnaire. They are very interesting. I am trying to draw guidelines on the practical implementation of the regulation, reform proposal at the European level, but also there are many very interesting reform proposals at the national level, and also policy recommendation. In the next day, I will send you the documents with these guidelines from proposal and policy recommendation. This is the results of our work, and in my opinion, in our opinion, it is a very one of our deliverables, which can be interesting to give a little contribution to the implementation of the regulation. There are some general indications, for example, issuing guidelines and enforcement of the regulation, but issuing guidelines, training with the competent authorities and so on. But in some questionnaire, I found some very specific also indication, which are very interesting. For example, the implementation of Article 7 for the freezing. Your question was wonderful, because with a lot of very specific deep indication, guidelines, reform proposal, and so on. But also everybody has given a very important contribution. So today we are focusing on hard cases. Before to start, I suppose that Matteo would.
Yes, I have really brief logistical, let's say, indication. First of all, welcome everybody here in Milan on behalf of Transcrime and the Catholic University of the Sacred Heart. And the first thing is we have quite a busy, I would say, schedule. So please, for what is in your power, stick to times, because we have a lot of intervention, and this will allow us to eat tonight, because at probably 8:30 you will want to close everything. So of course they will not close us inside, but we have to stick to times. Second thing, please send me your PowerPoint presentations if you haven't, because as you can see, the directorship, let's say, the guiding is centralized, so we need to have them before in order to project them on the screens on the call. Then please, I will circulate the schedule, the paper for presents. Please sign it. And then we have an additional module for GDPR issues in order to take photos and deal with very few data of yours, such as your image, but this is just, normal procedures for taking photos within the Catholic University of the Sacred Heart. And you can find the credential of the Wi-Fi on the table. And then finally, we have this stick, this presenter, for the ones that are speaking, in order to take the control of the presentation that we are projecting. So we will have this stick passing through the presenter. So welcome again. Thank you very much. And I leave the floor to the first presenter then.
Okay. Dr. Fonte is a legal advisor for Eurojust. Thank you so much for your availability to give your important, fundamental, I would like to say, contribution to our project today and tomorrow. Please, I give you the floor.
Please, we have a presentation. Thanks.
Okay. So my name is Susanna Font. In reality, I should be here with Aldo Ingangi, who is the acting national member for the Italian desk. Aldo sends his apologies. He was doing his best to be here at this very moment, but he has another engagement, and he will try to connect at a later stage. My name is Susanna Font. I am the team leader of the economic crime with the operations department, and I collaborate in matters that have to do with asset recovery, money laundering, and economic crimes in general. I've been working at Eurojust for 12 years, and my background is I was a lawyer in Portugal and a public prosecutor in Scotland, and it's my pleasure to be here today. What I will do, if you agree, is I will today briefly cover the support that Eurojust provides to national authorities in asset recovery cases. That's the first bullet point. And tomorrow, we will look into Eurojust's experience in the very practical application of the regulation. So today is more general, and I will do this on the basis of studies of the Eurojust cases, so cases that your authorities bring to Eurojust or that were opened by Eurojust on their own initiative, thanks to information that Eurojust, so the national desks, became aware by virtue of exchange of information in coordination meetings, operational, and that resulted in cases being opened in your member states. So we have produced the Eurojust report on casework in asset recovery and the one on money laundering that is more recent, published last year. So our role is to assist the competent authorities to recover the criminal assets and contribute to the fight against crime. And we do that, and we assist our national authorities in all stages of the asset recovery process. We do that, and we've seen this by analyzing cases from all desks and all national desks, so EU member states, but also liaison prosecutors, meaning third states at Eurojust, represented at Eurojust, in terms of tracing assets, the freezing, the confiscation, and to the point of the disposal. And this includes the return of the assets, compensation or restitution of victims. This now includes by virtue of the regulation or with other instruments in the past that did not include, of course, the framework decision 2003 and 6, but letters of request on the basis of other instruments, and of course the sharing of assets. Yes. These are some of the challenges that we have been able to see in international cooperation, and that we are able, thanks to having in-house at our desks with the support of the administration, meaning colleagues that are judicial cooperation officers in this type of matters. Coordination and collaboration in multiple jurisdictions, the complexity and variety of international instruments. We have seen the civil and the criminal model. We have seen the recognition and enforcement of civil confiscation orders. We are seen the ability to act quickly to avoid the dissipation of assets. You will keep this this PowerPoint, and here is the report on asset recovery that is available on our website. And here, going back to our conversation earlier on with Professor Savona, what we did was we identified the main legal and practical issues in the application of what was at the time the framework decisions 2003 and 2006, and what we are doing, and this is what I'll be going into more detail tomorrow, what we are doing now is we are studying Eurojust cases, so from the several desks, and analyzing what are the main legal and practical issues and best practice in the application of the regulation.
Very interesting.
Yes, yeah. So what I was discussing with my colleague before the meeting, we have been in other fora before, that what we see are problems in Spain and that are not at all problems in Italy. I know some problems that have been identified in Italy.
Depending on the social, economic, and geographical context.
Very much so.
Legislative. And
very much so on the legal system. Yes, the legal system that, for example, you have in Italy, that allows, and now I speak now a little bit off the PowerPoint, but this is how the discussions are. Sure. I know some specificities. I work with Filippo Spiezia a lot, and with the Italian desk, with Aldo, Silvio, and with Teresa Magno, with all of them, with Sergio, because I support many Italian cases, and I am aware that, for example, the scope of the regulation has been an issue during the negotiations, is an issue still now in the recognition in some countries, like, for example, Romania, to be open, because that's what we're here for, and this is what makes these events fruitful, to overcome and to facilitate the dialogue, and to overcome these sometimes misunderstandings, and try to find solutions, because there is no other way. It cannot be that one person speaks, gives the back to each other. Anyway, we will come to that in more detail if you agree tomorrow. So what we have found is that we have seen that we have the benefit. We have seen the benefit of identifying appropriate correspondent national authorities, even prior to seeking the assistance of using specialized forensic accountants, both in the investigation financial information and also as potential expert in testimony, and also a multidisciplinary approach to asset tracing at EU level. It may be, I will go through this and I will make a comment. Raising awareness amongst national practitioners of the statutory responsibilities of AROs and FIUs, requesting full investigation by an asset recovery office, and including a financial inquiry as an objective in all joint investigation team agreements. I'll stop here, and from the events and such as this one and other ones where we have all been part of, I'm sure, have been able to see that there is a diversity, a décalage, I would say, yes, a diversity, but also a diversity, but also more than a diversity. There are countries that are very, let's say, advanced in terms of investment in this area. And there are others that, by lack of resources, lack of awareness, the priorities being elsewhere, and are not at the same level or even a closer level. And we see more and more that there are several, for example, when we prepared this report at Eurojust, when we were analyzing the cases and speaking with our national desks, so with judges and prosecutors, and analyzing what we saw from the desks, we saw insufficient awareness at the time of the work of the asset recovery offices, of the work of the financial investigation units. And this will be perhaps, I dare say, or I have seen as well in other fora, that vice versa, the work of Eurojust, how can Eurojust support? So this dialogue that has, and when I say Eurojust, I mean also prosecutors, and I mean juges d'instruction, investigating judges. This is an area that is very multidisciplinary. This is me to shut up. It is. Well, you will have my presentation. If this is for me to be quiet, it means that I don't control my time.
No, please keep going. Don't worry.
But perhaps it's a bit. I will not say the regulation as such, because we are in the middle. So I'm not in a position yet to present those results. But what I can say is that, for example, we see that the area of cryptocurrencies, because we cannot see these things in isolation. The regulation cannot be seen in isolation. We have to see the regulation together with the with the legislation, as out of everyone, the academia followed the legislative progress at EU level and how the implementation is being done in the member states. Sure. Sure.
Extremely helpful for the projects. You will see tomorrow when Matteo and Pietro will show this table about the gaps and to make a typology of the main difficulties, which means you said one, asymmetries in legislation. The requesting country does not meet the country. Okay, this is one, for sure. We know in Europe, we do not have the same legislation. So we need to approximate, and this is really a bureaucratic language, not harmonized because the people don't speak about harmonization. Approximate legislation. But it will be interesting what of the existing legislation does not work. And if something works in the Netherlands and not works in Italy when they request, or in Bulgaria or something. But it will be extremely helpful for us to have a typology of the difficulties. For example, legislation is one. Police cooperation, which means they do not investigate sufficiently about the ARO role, which will be extremely interesting to do. You say mentioning ARO and FIU, which are having problems. It could be that sometimes the police does not really respond to the request because they are not capable to investigate it. They don't have the energies or resources for doing that. They don't have instruments. If you ask to a Bulgarian police, probably they don't have instruments for investigating. They don't have the organization. It will be interesting, but you can do as a homework when you come back to your hotel room, a typology of the difficulties. These will be, because are different, legislation, police cooperation, judicial, all these things.
What we saw, we did we organized the meeting. Probably some of you attended at Eurojust in June this year. It was the first meeting on money laundering and asset recovery, and we were able to cover issues, because both are very linked, and we
got to the report coming from there. We got to the report. There are something that I'm asking in this report, but not completed.
Yes, the outcome report as such, I will touch upon it tomorrow. It is not finalized. But okay. One of the, to come to you.
Okay.
What we managed to gather in that meeting, judges, prosecutors, representatives from AROs, representatives from FIUs, and to give presentations, representatives from law enforcement.
Very important.
Representatives from the prosecution service who are specialists from the prosecution service and from law enforcement who are specialists in the seizing of cryptocurrencies. And we saw the interest, because these days you search, you enter into a flat, you search, you seize the computer, and there are crypto wallets in it.
Yeah.
There you go. And what the difference is that, for example, we have seen, I go back to specifics.
Okay, good.
Is that?
But is this report available? Or
this report is not yet available, but it will be available.
Don't forget to send us when it's.
Okay. I will do.
Okay.
Well, I see I had a lot to say, but others also, if my time is up.
Okay.
Well, you tell me. I was just going to say that we also assist in the freezing and confiscation by actually anticipating questions relative to the rights of third parties. We assist, meaning when you consult with us, when you come to us, it's because when I say you, I mean the national authorities, of course. And we help, so the desks, with the support of the staff, understand what type of legal instrument is best applicable. That is also something that sometimes a national authority may think that, okay, I will issue a freezing order on the basis of such and such, but there are other countries involved, and they realize that, okay, no, in the end, it will not be you doing that, because if you do that, then I will not be able to prosecute. So the strategy and what we see is that still there is insufficient, going back to you, to the awareness. There is still insufficient awareness of Eurojust. I give an example. I arrived last night and I asked a police officer, where can you give me the direction to go to my hotel, blah, 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 blah.
Mm-hmm.
And then in the end, I said, thank you. Eurojust thanks you. And he went, huh? And he said, you know Europol, yeah? Oh, yeah, yeah, yeah. And Eurojust? No, no, no. So this is something that we have to work on. Sorry. This you will have ample time to go to. This is the advice that we give in all stages. I will give a concrete example, and then I will shut up. This is a case. This is a case where two colleagues of mine, two judicial cooperation officers like me and I, assisted. This was what we call. We were in what we call a coordination center. Some of you will be aware, we have a dedicated room at Eurojust where on a common action day, where actions have to take place at the same time in several countries, we coordinate. Let's say it's something like this room, but smaller, with screens, and we have the national desks representatives in contact with the officers back home, and in contact with each other when the guys at the same time do the searches and arrest the guys. On this occasion, what happened? Several freezing orders had to be several, very many, and in member states and in third states. I don't put countries because we cannot, in our reports, mention which countries there are. So what happened was that during the searches, as they were taking place, it resulted that there was information of one more bank account. So at that very moment, plus at this coordination center, the prosecutor, this can also happen, that the actual prosecutor, let's say from Leiden in Holland, was there. So at Eurojust, he issued the freezing order, the certificate, and it was sent immediately for execution. But it was not translated. It was, let's say, in Dutch, and it had to be translated, I'll make something up, into Hungarian. Well, it just so happened that my colleague who was assisting with me was Hungarian. So he translated into Hungarian, and it was able to send it at that moment, and the actual then proper official translation was sent afterwards. But that enabled that the freezing of those assets, which was, I think, in a third state on the other side of the world, could take place. And that meant that 3 million euro could be frozen. So this is an actual effective result. So what I would like to flag today, you will also see in our money laundering report that covers, I'll come to my conclusion afterwards and I will shut up. The money laundering, we did a money laundering report at the end of last year. Part of it covers a lot on financial and banking information and a lot on asset recovery, as you will see from the screen. And of the 10 most relevant legal and practical issues and best practices, most of them, I put several to be humble, but most of them have to do with asset recovery. They have to do with still insufficient awareness of the issues with the regulation, or way more in some countries and less in others. Sorry if I look more that way, because it's easier for me. I don't want to be rude to our colleagues here. Issues related with how to divide the assets when there are several victims, the restitution of victims in several countries, difficulties with cryptocurrencies, and the issue, of course, of beneficial ownership, because the several issues of that are being discussed at EU level. So the anti-money laundering package that is still being discussed, that we follow, of course, these developments, and we are, as an agency, consulted on these proposals, like other stakeholders, because we have cases, your cases that are transnational. So when I say we, Eurojust, are in a position to see the most relevant cross-border cases. But for that, there has to be more and more awareness and more inclusion, way more multidisciplinary work at national level. And this, without preempting what I will say tomorrow for the other audience as well, one of the outcomes of the meeting on money laundering and asset recovery was that we held in June with this composition that I outlined before, was a great support for the setting up of a focus group that would encompass a group, although prosecution represented, but that would encompass a multi-layered at national level composition that would encompass this multidisciplinary involvement of these actors that I am talking about, because there is no way that without at national level a better dialogue. If at national level the dialogue is not better, then it doesn't come to a better cross-border at transnational. And now I will be quiet.
In few words, extremely interesting, because for us, and thanks a lot for this, I can make a final statement. More the legislation works about money laundering, easier will be the implementation of the regulation. In few words, this is what we are requesting, because beneficial owner, it's one of the key elements, from a lot of time, is a key element. So if the European Union will be capable to implement mandatory the request of the beneficial owner, easier will be, of course, because they can identify who is the person in charge. Let me say, from the point of view of criminals, we will make a lot of obstacles to this, because this could be absolutely important. Yeah.
Absolutely, and also not only these registers of beneficial ownership, but also the register of the central banking registers. So something that is already
set up. They are discussing about the common register
It is already EU law, but it's not, and we see this in the money laundering report. There's a section on it. Not all countries have. I don't know now. Romania. Look at my Romanian colleague. Does this exist already in Romania? Because at the time when we did the report, I don't think it existed, but I don't know if now.
Have a national bank account
Uh-huh.
registered, but there are some problems when we transmit the information because we can't transmit it like a proof. We can transmit it only like an intelligence or purpose, because for proof we need a special authorization from a judge, so on and so forth. So it's a problem, and this problem can be um, uh, solved from the new proposal of the new directive on confiscation as a recovery. But I think Romania and I don't know, Luxembourg maybe was the only states who wanted that this type of information to be proved in all cases. The majority of the states didn't want it. I already put it in our report. It's the Article 9, paragraph 4, and it's the same thing like in the last instrument from Directive 42. And it's not, I don't know why, many states don't want this to all the information to be transferred as a proof from between arrows. 9 paragraph 4. That's the key.
Thank you. Improving the awareness of the role of Eurojust is one of our policy recommendation, but only one state declared in the questionnaire that there is this problem, Portugal. The other questioner they say, okay, yes, the judicial authorities, the prosecutor, and so on have enough awareness of the role of Eurojust. Only Portugal wrote that there is this problem of the awareness, that there is the lack of awareness of the role of Eurojust in this complex case, in this, for the state recovery. No, tomorrow. Yeah.
I cannot speak as Portugal because it just so happens that I'm Portuguese.
Yeah.
But I am here in in that capacity.
Yeah.
None
Okay.
whatsoever.
No.
But what I do, so I will. I will have to leave that for my colleague. So I'm Portuguese.
No, but I think that it is not all a problem of Portugal. That is,
I know.
family, not every judge or every prosecutor has this real awareness. Yeah, I am of this opinion. Okay, and also other indications are in our policy recommendation. For example, one of the proposal of Germany is the introduction in member states of a central register for the different assets. And also, because in Germany there is this specific problem, the organization of the real estates on the basis of the name of the owners. This is maybe more specific German problem, but this is important to identify the owners. Also, this is one of our, and also this general problem, the training of the competent authorities about the introduction, because also I do not remember Portugal, but Netherlands wrote that there is this problem that sometimes authorities didn't use the regulation, but the old instruments. So this is also the problem. Training, no? Okay. So we can.
If I may, just a very quick point. Whenever you speak, please use a microphone because we are connected in a call, so this will allow the persons that are following us from home to hear everything you say. And secondly, I forgot to mention that, of course, the call is recorded, and we are here with the, I presume, the consent of all the persons that are here. If this is not so, please tell me and we will try to arrange this thing, but for just a GDPR issue. Thank you very much.
Okay, so now we got we have the presentation. Maybe would you like you to introduce you?
An additional point, the registration will be published in our website into the relevant database. And that is definitely all. Thanks.
Dr. Fini of the Ministry of Italian Ministry of Justice.
Thank you. Good afternoon, everyone. First of all, I want to thank Professor Savona and Margeri for all the, of course, also their team for all the work they've been doing so far, and they will be doing with a view to achieve the goal, to achieving the goal of a better and wider implementation of the regulation. As you know, maybe the Ministry of Justice in Italy, according to the current legal framework, it's just a channel for communication. We receive from foreign authorities certificates, and we forward them to our judicial authorities, and also the other way up. In the other way up, we receive the certificates issued by our authority and forward them to the foreign authorities. I just said and emphasized according to the current legal framework, because we are really about to have a new law going through, which will adapt the Italian legal framework to the regulation in terms of judicial authorities competent, but also in terms of the other key features of the European regulation. As we have to stick to our schedules, tight schedule, and I will have the chance to also to talk to you tomorrow. I will now give the floor to my colleague Federico Perone Capano, who will introduce to you a really interesting case he has been carrying followed in his capacity as a public prosecutor at the prosecutor office in Bari. Federico, the floor is yours.
Yes, we are arranging the connection.
Can you hear me?
Yes,
Can you hear me?
perfectly.
Okay.
Yes,
Perfect. Okay.
perfectly. Thanks.
Thank you very much for the floor, and and a special thank to the organizer for inviting me. Let me first introduce myself. My name is Federico Perone Capano. I work as a prosecutor. I have 20 years of experience. I have mainly worked in the anti-mafia directories in two different offices, but I also dealt with cases of tax and companies related crimes. I have also 15 years of experience in international cooperation, and I am actually the EJN contact point for the district of the Court of Appeal in Bari. I will try to stick to the times, and I am very sorry. I don't know if I will be able to participate to the workshop until the end, because I have to prepare my hearing for tomorrow. But I really hope that I can stay with you until the break. So first of all, let me say that I totally agree with what Ms. Fonte just said. Maybe I will, if I have the time, I will add some considerations at the end of my presentation. Okay, the case I will talk you about has started in 2015. I can freely speak of that because we have definitive convictions for most of the defendants. And we issued the certificates for confiscation after the regulation was issued. The object of the case, the charges, were were quite peculiar. They were charges for criminal conspiracy. And this organization has had the purpose of the abusive collection of bets and the connected tax crimes and money laundering, and also the fictitious heading of assets. This is a specific crime that is in our criminal law, and that disposition punishes those people that make a fictitious heading of money or of assets in order to avoid the specific in-rem measures that are provided by another law in our system, or in order to commit money laundering crimes. Some of the suspects, and they then became defendants, were part or related to some mafia-type organizations that are in Bari. And that's the reason why the Anti-Mafia Directorate was carried on the investigation. And we discovered that there was a worldwide network that was organized with many companies that were based throughout the world, mainly in countries with privileged taxation. I'm talking about Virgin Islands, Bahamas, Malta also, and Seychelles, and with the fiduciary companies in Malta. The brand was Bet128. It was a bookmaker, let's say, brand in Italy. And they had a pyramidal structure. There were master agents and sub-agents with many with a very broad and extended network of PCs and smartphones connected to the internet in order to collect those bets. And the collection of bets was structured in order to allow the placing on bets on websites that were not authorized by the competent Italian authorities. That was and they used servers that were placed in Malta and in Romania. The organization was also able to immediately switch and change the websites every time the websites were blocked by the Italian competent authorities. And this system was conceived to avoid paying taxes and fees on the collection of bets, and this way to allow the money laundering in many cases. The defendants, as I said, were charged with the aggravating circumstance of the transnationality on the basis of Article 61 bis of the criminal Italian code. That is the transposition of the UNTOC, the United Nations Treaty on Organized Crime, and the Convention of Palermo of 2000. And on November the 9th of 2018, the judge for preliminary investigation, on the request of the prosecution office in Bari, ordered the arrest of 22 people. 7 went to jail and 15 of them went to house arrests, and ordered a very big seizure. Consider that the amount of profits of the organization was 650 millions of euros. And so there was the seizure was structured in 3 different ways. There was a seizure of the companies and the instruments, the PCs, the smartphones, and the tablets, in order to block the criminal activity of the organization. But there was also a seizure of assets that was of the profits of the organization. That was also per equivalent for the the same sum that as the profit. And also there was a seizure for disproportion, that is a specific measure in the Italian system. And it is allowed when a person that is suspected of a crime committed by a criminal organization cannot justify the legal the where that money is coming from, or how those goods were bought. We ask, as you can imagine, we ask for a very broad international cooperation. And let me say and underline again that Eurojust made an amazing work in supporting our requests. We made requests to Malta, to UK, to Germany, and through the Ministry of Justice also to Australia. And we had, and it was made in both forms. We we had a certificate based on the directive, the previous directive. So we had a freezing certificate. And we also had many European investigation order in order to follow the money. We had a 50% result, but it was anyway quite, we can be satisfied of the results of international cooperation in this case. Because, for example, two very expensive apartments were seized in the UK, in Great Britain, and even if it was, we were on the verge of Brexit, so with all the issues of the continuous modifications of the agreements between the countries, we had the seizure that was immediately executed of 50,000 euros on a bank account in Germany. We were able to seize an oceanic catamaran in Australia. And actually, we are trying to obtain the confiscation. No, we already had the confiscation. We are trying to sell it in Australia. At the end of the trial, since the investigation was really a solid one, many of the defendants plea bargained with the prosecution office, so accepting that the confiscation of the assets, and the other defendants chose the shortened trial, and and also in that case, the conviction is executive with the confiscation of the assets. Actually, we only have 3 defendants that are still in court, and we are still in first grade. On January, probably we will have the decision or the discussion of the trial. So we were able to, as I said, to confiscate quite a good amount of assets, and we had just one issue that was when I issued the confiscation certificate, was about the notion of the issuing authority, because according to Article 2, Paragraph 8, letter B of the regulation, we had a doubt if the certificate of confiscation was to be issued by the prosecution office or by the judge that decided the case. But since our legal system, Article 655 of the Criminal Procedure Code and following, states that it is the prosecution office that cures the execution of the penalty and of all the penalties, we decided, and we also had an exchange of opinion with the ministry, that the issuing authority was the prosecution office, and so we issued the certificate that was executed in Germany. The other now let me stress out a couple of considerations. So I think that I'm sticking to the times. The first, I think that one challenge might be the management of the seized assets. It goes under Article 28 of the regulation. The point is that Article 28 says that the management of the seized asset is regulated by the law of the executing state, and obviously that is agreeable. But the point is that, for example, in this case, where we had a lot of assets seized in Italy and part of them also abroad. The point is that we had some administrators that were nominated by the judge at the moment that of the decree of seizure. But the point is that they, at this very moment, they don't know anything of what happened with the seized assets, not the money, obviously, in the other country. For example, we had a quite an exchange of letters and documents with the Australian, for example, and the UK. Obviously, we are out of the regulation, but I think that the problem is the same with other countries. But we know very little about what happened with these seized assets. For example, we don't know if the apartments, the buildings that were seized in the UK, if there was a location, if there was a rent, and who got the rent. We suspect, for example, that the rent was still paid to our defendants, but we don't know anything about what happened, and we are asking for information and also for the execution of the confiscation to the United Kingdom. So the point is that obviously, I think that we need some kind of even I would say cooperation between the judicial administrators that are in Italy with the ones eventually nominated by the executing state. And very little is in the regulation, and we know very little about. There should be a best practice about this. And the other point, and I will connect to what Ms. Fonte said, is the total lack of awareness. As an AGN contact point, it happens to me quite often when I am consulted by my colleagues that I have to tell them, for example, that regulation exists. Some of them don't even know about this. And they don't know exactly what to do, what they have to do with to have a freezing certificate. So most of the times when it is a freezing certificate, I tell them that they should have first of all, a decree of seizure by the judge for preliminary investigation that is competent for the internal law. And after that, it is the judge that has to prepare the freezing certificate, and then we can eventually just send it through Eurojust or directly in order to have it executed at abroad. And also there is, as Ms. Fonte said, there is a very big lack of information about asset recovery offices and financial investigative units. I suspect that some colleagues don't even know that Italy has a financial investigation unit. And the point is that there is also, this is the second point, very little exchange of information before executing the request for the freezing certificate, or even the request for EIOs. Because, for example, a direct contact or via Eurojust might be useful to give an exact shape to the request, For example, requesting for the intervention of the asset recovery offices or financial investigation unit in the executing state. This is my point of view. I hope I was clear. If you have any question, I'm here to answer.
Okay, thank you so much. So there are many interesting elements in your case. I would like to ask you, one of the position of the Netherlands is that it is not necessary the European investigation order in order to find the assets to confiscate, but it is enough, if I have correctly understood, the freezing order on the basis of Article 7 of the regulation. Is correct, this position?
Yes, it's enough that you have a reasonable ground to suspect that their assets are in a certain member state. Then you can send a European freezing order. And Article 7 of the regulation states that the member state that is executing the freezing order is able to take all measures that are also possible in national cases. So if the location of the property is not exactly clear, but there is a reasonable suspicion that it is in another member state, the other member state should be able to assist in finding the exact location of that asset in their member state, because they have the better tools and to perform that investigation nationally in order to execute that freezing order. And the same way, they should be able to investigate other assets as well in that member state if you have, especially if you have a freezing order that is aimed at value confiscation, and you already also indicated you are willing to freeze assets of equivalent value. Then also, if you have reasonable ground to send a freezing order to another member state, that other member state should be able to, on national competence, investigate all the assets of that suspect in that member state in order to freeze as many assets as possible in order to execute that freezing order. So it's not reasonable under the regulation to expect from the issuing state to have all that information prior to sending the freezing order. That's not possible. So we should help each other with that better.
No, so the question is, so in this case, don't you consider the possibility not use using the European investigation order, which is in any case demands time, but to use directly the freezing order in order to force the foreign authorities to investigate in order to find the assets?
Okay, I think the question is to me. The point is that we were able to seize and then confiscate some assets that we already knew that were in that place. We used the European investigation order in some cases because we needed some more information about the companies. It was, going deeper into the investigation because we did the first part, which was that was completely at a national level, but we started the international cooperation only after we had the the measure for the arrest and for the seizure. Probably in the future it might be that should have been a very good idea in order to have a freezing order and to ask the executing state to seize all the assets up to the value, and so they would be able and free to make a research through their financial investigation units or assets recovery offices.
Okay, thanks. So the other aspect, and I give you the floor, is the problem of the management of the seized assets. Because in Italy, we have a specific legislation. No, the judge appoints a a judicial administrator, and so on. And we have the problems in any case. But I have the feeling that in some countries there isn't this kind of legislation. So the problem in the future is that the regulation maybe has to be extended also to give some rule about to impose member states some rule about not suggest but impose some rule about the management of the seized assets. Please, I give you the floor. And if you also other would like to ask, please.
If I may, I found just a couple of points. I found very interesting what you said about the Netherlands. So if I understand, to seek the tracing of assets in the Netherlands. So first to seek the tracing and thereafter the freezing, you can do that by issuing a certificate already. So there's no two-step.
Well, the first step is you have to have enough information to suspect that in the Netherlands there are assets from the suspect. But if you don't exactly know where it is or how many assets the suspect has, it's possible to request if you have, for instance, estimated criminal profits of 1 million euros, and your investigation is aiming at getting assets up to that value. You have the knowledge that at least he has one bank account in the Netherlands. You can ask via the freezing order to freeze the bank account and look for possible other assets up to that 1 million.
But that's what I'm saying. So the instrument as such is already the freezing order.
Yes.
That's the only instrument. So there isn't there. What if I do not know? What if I do not know how many bank accounts the guy has? So I'm actually asking. So I explain. I'm investigating such and such for the such and such crime. He has links to such and such. We have strong reasons to believe that such and such and such and such. However, we do not have the number of his bank accounts, but we suspect he has several for these reasons. We also have reasons to believe that he has property. So I explained, but I do not have, so I don't have more. But I issue the freezing certificate. Is that the case? Because in some countries, there is an EIO issued. In other countries, and now I make a brackets, the EIO is, as we know, is an instrument to seek evidence.
Yeah, yes.
Is an instrument to seek evidence.
Yes.
But it's an instrument that can be used, or is being used, or it can be used when we want the asset as evidence, and we want to safeguard that we never know what is in the boat. We want the boat as evidence in the drugs case, but we never know if there might be money in the boat, and the boat itself is worth money if it's a big boat. So we want the boat and the contents of the boat as evidence, but we also want it, or to safeguard the possibility of having it in the future for the purpose of confiscation. And one of the things that we have seen in our cases is that in the EIO, together with the very many measures that one may seek from another country, I would like the searches of such and such. I would like the interrogation of such and such. I would like the boat and other assets. And when I don't know, I would like that these assets are also for freezing. what I was not aware, and this is a novelty. So thank you very much for sharing the experience. Was that without knowing, like the tracing actually is being sought with the actual freezing certificate already under Article 7.
Yeah, so let me give you an example that might illustrate it as well. We see in many cases that a EO is sent for instance, a house search, several house searches. From experience, we know if you do a house search, you find valuable assets as well. But the EO is not meant for freezing valuable assets. But you know, when you go search a house, you find them. So if you are investigating a case and you also are including a confiscation procedure and you're also looking for those valuable assets to be frozen, don't only send an EO, but send a freezing order as well, explaining that you have sent an EO for the house search, that you are conducting a confiscation case as well, that what value, estimated value of the financial gains you have estimated in that case, and up to what value you seek the freezing of assets, and ask the authorities to, when performing those house searches on basis of the EO, also look for all those valuable assets and freeze them on the basis of the freezing order.
I think it depends from the legislation, because, for example, in Romania, we can issue an order, a freezing order, to a maximum limit, even if we cannot identify the object or the individual assets. But I think there are countries where you cannot freeze something which is only a sum in general. You need to point it out. So it depends. Yes, for us is a very good example, and in cooperation we can apply Article 7, of course, if the executing state have the capacity to identify and I don't know, bona fide to identify all the things, not immediately, not after 8 months. And at the second point about management, about type of management, I want to say that in the new directive of confiscation, now it's negotiating an article about managing the shares, the social part. I don't know. It is very important to be regulated that point, even if it will be in the competence of in the other judicial competence, like in civil courts or in the executors. I don't know which is the name exactly, but not because the criminal courts, they don't know how to manage maybe an legal person, but a civil court can manage it, even if we are in a criminal proceeding. Thank you.
Anna?
In your case, you mentioned, thank you for Mr. Capano for your presentation. So you mentioned that you didn't have any freezing of the company's shares, because you mentioned the instrumentalities, you mentioned also the assets, but not the shares of the companies. This was the first question. Second, you said something really interesting with the plea bargaining. So I didn't understand if also confiscation issues were kind of inside the plea bargaining, or just the sanctions, because this would be also something interesting. And the third point, and I think this is the most important for our project, is maybe first, if we are interested, because I understood that you had problem with the Italian law, that it's not yet, as you mentioned, that it's doing the clarification to the regulation, so national legislation that is clarifying the regulation, that you don't have it yet in Italy. So you're just having the law of the framework decision 2006 for the moment.
The national law implementing those framework decision, but really in these days the new law is going to go through. So
okay,
This is the regulation. We have to apply.
But from the
Also without law, without national law, we have to apply the regulation. It's a regulation.
And we
But-
do apply
It's
it.
not a directive. It's a regulation.
We do apply
are
it.
applying.
it is like that, but I think every state, like every member state, and the majority of them, they are making this new like declaration, like new law. And this, I think it's
We have the
We
declaration.
have the declaration according to Article 24, Part 2 of the regulation, and we do apply the regulation. The new law is only about to adapt the
Exactly.
internal, the overall internal legal framework to the regulation, but we already are on that track, so we already doing our job.
This
But-
is no, the new over the regulations, that is a regulation. You see, it's not, it's mandatory.
just because I think that some like from this interviews in Cyprus, in Greece, and other countries, like in Greece, we don't have such a law yet, and I think it's interesting because they are about to doing now, and this is specifying the authorities and some changes the competent authorities, and there is this European Justice Network document that it's saying for the clarification, which is the translation, the languages, etc. And maybe for you, I mean, the practitioners would be interesting as from our project to say that in this document of the European Justice Network, we need also to have these new legislations from each member state as a clarification, because then it would be for you, I think, a lot more easy to find it. So this was the first point as from our project. And the second point was for the amendment that you said for the management. From an interview with the RO in Cyprus, she told me that it's really important, like an amendment to have in the certificate or in the regulation. And you mentioned it also, Mr. Capano, that you have the executing state should come back and inform all the several member states, issuing member states, about the result of what happened with the case, because this is not yet in the regulation as obligatory, like proceeding as an obligation. So this was another point that maybe from the project we can say that it's an amendment.
Is one of the guidelines, because I don't remember if in Netherlands or in other countries suggested this is important, the information, because there is also the problem that if you don't inform the issuing states of the results, the problem is that in the end, the confiscation order can not include some assets, because the issuing authority does not the results of the. So this is one of the, I don't remember if it's guidelines or reform proposal. I have this guidelines reform proposal, policy recommendation, but it is in this last document that I am pending. There is also this proposal. Okay, other.
Yeah, maybe if I may, because the regulation does state, and I believe it's in Article 7, paragraph 2, that the executing member state should report back to the issuing authority which assets are frozen, and if available, also the estimated value of their property. So it's not being done yet in all the cases, but it is in the regulation that it's prescribed that you should do it. And that is really important. And one of the proposals we have done is to make standard forms for these messages, reports between the member states to facilitate that these reports are actually done by the executing authorities.
I would have just a small curiosity on this point mainly, meaning in terms of guarantees, if we have a freezing order from an issuing state that is blank, I would say white, let's say, let's search for the properties, as you were mentioning, of this subject, also up to this value and everything, then the subject that has his things frozen will appeal or contestate the act in front of the national authorities, or in front of the executing authorities, or in front of the issuing authorities, because who is actually freezing? Probably the executing authority, but then the order comes from the issuing. So what are the problems there in terms of guarantees for the subject?
I believe that's not different than when in the certificate one specific asset is named and that is frozen in the executing authority. I think appeals that can be made in the executing authority is whether or not there should be a ground for refusal for the freezing order, and if the national procedures for the freezing are being followed. So these grounds, they can be appealed in the executing state. And the other grounds, you would like to appeal that for that case up to that amount assets are frozen, that is an appeal you have to make in issuing authority, issuing state, and not in the executing state, because it's not the executing state that decides that for the suspect, Mr. X, assets up to a value of €1 million has to be frozen. That is the issuing state that decides that.
Okay, yeah.
There is also the Article 33, no? The provides substantive reason might be, only before the judicial authority of the issuing states, but before the judicial authority of the executing states, each interested party, also third parties, must have appropriate means of appeal to protect their rights, according to the rules applicable in the legislation of the states. Also, it is in the regulation. Please.
We had some issue about that after a freezing about a maximum debt from another state, in Italy. The citizen from Italy wanted to switch, to change some goods, some assets, because he wanted to change an apartment with a land. And this problem will be solved from the court from Italy as an executing state, or from the court in Romania as an issuing state. In that matter, our opinion was the Romanian court as an issuing state need to have the competence to change, to transfer the freezing from a good, from an asset to another asset, even if, as our colleague said, in the matter of executing under the maximum level, it's only in the competence of own execution authority to have different complaints to resolve it. Maybe if the executing state have another not €1 million, maybe €3 million, freezing the €3 million. I think it was about competence in the executing authority to solve that matter, because it
is also a problem of the kind of confiscation, because or for Italian legislation, because there are some form of confiscation which points specific assets because they have a criminal origin. There are the form of extended confiscation because there are some disproportionate value and so on. There is the confiscation with the value where there is no problem, you can change, because what is important is the value, but not the specific. This is yeah. Yeah. So, Adam, please.
If I can just add something to what our colleague Federico, thank you, Federico, for your presentation. And I'm happy to hear that your case went well with the assistance of Eurojust. You mentioned something about the judicial administrator. I understand that there is such a figure under the Italian system. What we've been able to see in our casework is that there are countries where that entity does not exist in their legal system. That in itself is a difficulty. So when I hear the proposal, which would be excellent, that the judicial administrator, someone appointed by the court, which to me is absolutely familiar, to me personally, and by the court in the executing country, and the issuing authority and the issuing authority or his counterpart, if that would be the case in the issuing country, that would be ideal. But in some cases, let's say Italy has such a figure, but there will not be a counterpart to speak to on the other in the other country. Another issue that I've heard is when what is being sought, and this I know from Italian cases, is when what is being seized are the shares of a company, a company. So not the walls, but the company, the management of the company, the running of the company. This is not possible, or this does not exist in some jurisdictions. This we also have seen in some cases at Eurojust. So we have had to find ways to make this compatible. And we have on some occasions been able, one has been a recent case, not one case where I've been involved, where although that had not been foreseen in the other country, in the end, it was, I don't know now the technical solution that was found, but what I would like to convey was that a dialogue was established in a way that, and this is what I would like to flag, is that we have oftentimes to be creative and to speak. There's nothing like sitting at a table and trying to understand each other and how to go about things that appear to be impossible and overcome difficulties. This was one of them. Thank you.
Would you like to say something other? Okay, Federico.
Yes, it was the discussion was very interesting after my presentation. I think that the point of dialogue is pretty important, because if you having a direct contact with the executing state is pretty important, even before they execute the certificate, because today, for example, I learned that in the Netherlands, it would be easier to have a seizure of assets, even if we don't know exactly what assets are going to be seized, and we don't even need an EIO, because the point is that during the investigation, the issuing authority in Italy for the EIO is the prosecution office. The certificate is issued by the judge for preliminary investigation. That is not like the judge of instruction in France or other offices. It is not an investigative office. And so the point is that probably having a dialogue, and in this Eurojust is very useful, with the competent authorities is the best way to shape the request. So let me underline this again, because as a prosecutor and a practitioner and an investigator, this is really important, because otherwise that becomes just, something that the executing state has just to do. It is, they have a different approach on the paper they receive. And if you have dialogue instead, probably they get more involved and they know exactly what you want and how to, and maybe even how to get it.
Thank you so much for your presentation, and thank you for the interesting debate. And now we can, I give the floor to the representative of the prosecutor office of the general prosecution office. Correct? Bulgarian. Please.
So thank you for the opportunity to be here with all of you and to present a case from Bulgaria. I got it from my colleagues, prosecutors, and although it might have has a different sound from the case that our Italian colleague presented, I think it's a good example and would raise a lot of discussions. So at the beginning of but please give me the device to switch the slides. Thank you. Which one? Okay. At the beginning of the presentation, I decided to point out some legal issues which are important to understand the case, but I will go through them very quickly. Our national law, as I have had the chance before to say, the Confiscation Orders Act, it implements the regulation. And here I just pointed that when Bulgaria is an executing country, the judge has some specific ways to decide the case, and they are in the law and as well as in the regulation. Secondly, according to the Confiscation Orders Act, this is something about the procedure. The court of first instance may issue a decision, and then the decision could be appealed in front of the court of appeal, and this decision is final. To reach a decision, the court of appeal has an open court session in presence of a lot of people, as you can see. The provisions of the Confiscation Orders Act do not contain special rules about everything, and when there is some lapse, then the Criminal Procedure Code shall apply. Further on, according to Criminal Procedure Code in Bulgaria, jurisdictions disputes between courts are decided by the Supreme Court of Cassation. And there is something important in Bulgaria. We have an extraordinary method to reopen a penal case when there are some issues concerning procedure infringements or some new evidence has been brought in front of the court, which were important to that decision. According to the practitioners, however, the final court rulings based on the Confiscation Orders Act does not fall into the scope of this rule about reopening, so consequently they cannot be reopened. These regulations now sound not connected, but just in a minute you will find out why I'm mention them. So the facts. In 2020, Sofia City Court through Eurojust received a request for recognition and execution of an Italian court decision. This decision, in addition to sentences for the guilty persons, imposed confiscations of money representing proceeds of crime. The money were located in two bank accounts owned by a Bulgarian trading company. The bank accounts had been previously frozen at the request of the Italian court order. Copies of 2 Italian court decisions were attached to the certificate, but without translation. The first decision was regarding the convicted persons, the crimes, and the punishments imposed by the court. The second additional decision was some kind of clarification that the confiscation imposed by the court against 3 of the convicted includes the value of the money transferred without valid reason to the Bulgarian company. In April 2021, the Sofia City Court recognized and accepted for execution the ruling of the Italian court regarding one of the 2 bank accounts. Only one, because the other one, the court found that it was closed long before the certificate was obtained in Bulgaria. It's interesting to be mentioned that during the hearing of the case, lawyers objected to the recognition of the decision with various arguments, but one of them is that the woman, owner and manager of the company, was not convicted in the case, in the Italian case, and did not know about the origin of the money. The court, of course, in the decision, replied that the executing state cannot and should not check whether the facts described in the confiscation act and the certificate have been proven. So this is the easy part, because the lawyers of the company appealed the decision to the decision of the Sofia City Court, and the Court of Appeal started a case that lasted more than a year and a half. With the decision from February 2023, the Court of Appeal revoked the previous of the first instance, refused to recognize and execute the decisions of the Italian court regarding the confiscation of the money of that bank account, and cancelled the freezing imposed on the bank account. So the money at that time were free to go. Another element is that during that time, the money were in the bank account because the company the company was in a procedure, in a civil procedure, when the debts were very enormous and the company could not pay them. And in that civil procedure, the court imposed a freezing again on the bank account. So in March this year, a prosecutor from Italy learned about the court decision. I mentioned again that it's final decision, and expressed his dissatisfaction with it in a letter to Eurojust. He requested the resumption of the court proceedings and the issuance of a new court act. Meanwhile, the regulation was went into force. So for this purpose, he sent a new certificate in which he expands the information about the facts established during the court case in Italy, and he explains exactly which is the relation between the convicted persons and the money transferred to the Bulgarian trading company. There was a confiscation preventive measure, and then is a confiscation of benefit origin from the crime. In this period, before receiving the second certificate, the seat of the company was changed. Sometimes, and very often, it's made on purpose from Sofia, from the capital, to another district city in Bulgaria, Stara Zagora. The second certificate was obtained at the Sofia prosecutor's office, again through Eurojust, the decisions of the courts in Sofia were reviewed at first at the prosecutor's office, and it was proposed from my colleagues to request the cancellation of the final decision of the Court of Appeal through that extraordinary method that I mentioned to reopen the case. But in that case, a decision of the Supreme Court of Cassation is needed. By our law, when violations of law are found in a finalized criminal case, only a prosecutor general can ask the Supreme Court to reopen the case. There is, in Bulgaria, there is no practice on this type of court cases. I mean, the court cases connected with the regulation and as a executing country for confiscation acts. And after a careful analysis of the criminal procedural code, it was found that the law did not provide for the possibility of requesting a reopening of these proceedings, and the prosecutor general refused to make such a request. He advised to the certificate to be sent to the court for a new trial. The prosecutor from the Sofia City Prosecutor's Office did so. So in June this year, the Sofia City Court started a new court case, but sent it to the district court in the city of Stara Zagora because the company is already registered in that city. 1 week later, a judge from that district court, after seeing that the certificate is based on a court decisions, Italian court decisions already considered by the Court of Appeal of Sofia, terminated the court case. He decided that the case is, and the principle non bis in idem applies here, because we have a regulation that says that if already a penal case is has been in front of a court and there is a decision, nobody can hear this case again. The judge further indicated that the only possibility to reconsider the Italian Republic's request for confiscation is to reopen the closed case. So that issue is in front of us again. But such a request can only be made the prosecutor. The case again went to Sofia City Prosecutor's Office, and after some correspondence with the Prosecutor General, an opinion was again formed that there is no legal basis for reopening the already concluded court case. There was a proposition to the prosecutor in Stara Zagora to appeal the court case, but he says that he considers the court decision as for non bis in idem ruling to be correct, and he refused to appeal that court decision. Then it has been started an informal correspondence, and the situation was explained to the colleagues from the prosecution in Italy, and we suggested them to issue a third certificate, but our colleagues said that they will not do that again, and I can't blame them, because I think they've done enough. But further on, but we don't stop here. After consultations, including with judges, because my colleague in Sofia City Prosecutor's Office decided to do more than others would do, she had discussions with the chief of the court in Sofia and sent them the certificate again. The two rulings of the Italian court and all additional documents and translations received were accompanied this time by a detailed motion for reconsideration. And the prosecutor in Sofia said that In fact, the judge from the district court Stara Zagora did not make a valid decision, and this decision is not in the scope of the types of decisions that regulation prescribe and the national law prescribes. And then a new case was opened in Sofia City Court and again sent to the District Court of Stara Zagora. Then the judge is instructed, the judge in the District Court is instructed to decide the case in a manner that the regulation and special law in Bulgaria provides. Then there was a dispute about jurisdiction because the district court in Stara Zagora says, yes, the company is seated in our district court, but the bank which holds the bank accounts is in Sofia. So the case again went to the Supreme Court of Cassation, and then the Supreme Court of Cassation finally again says, please, district court, the case is yours, so you should decide something. The court hearing was held in November. New translations of the court decisions, translations of the court decisions were requested from the issuing country, and the next hearing is scheduled for the beginning of December. So I think that we should make a lot of conclusions, and but I decided to choose some of them. And the first one is that the procedure in the executing country for recognition and execution can be extremely difficult, sometimes delayed and even hindered by procedural tricks, numerous requests for new evidence, and objections for non-compliance procedure in the issuing country. Another issue is that I said it in the answers of the last questionnaire. It's necessary to prevent these hinders through training, consultations, and in some cases a change in the legislation. I think that this case is a good or a bad example when a lack of correspondence, a lack of dialogue is in place. The problem in Bulgaria is that the trainings should be the judges and the prosecutors together should be trained, but the judges are the ones who has the final decision to execute and to accept for an execution the foreign acts. And this is the point that we should work more, I think. Another thing is that a clear and detailed description of the issuing country's request is essential to the outcome, because as you know, when the prosecutor and the judge has a case on which he has worked a lot of months and years, you know the case very good. But it's not the same for other persons. When you want the other country and another judge to do something, to confiscate money or any other assets, you should explain the details very, very well, because it is essential to obtain a quick decision, and this decision to be as we want to be. A meaningful and a well-made translation of the certificate and court decisions is also of utmost importance, because our special law says that Bulgaria as an executing country may translate the court rulings, but it is an obligation of the issuing country, and this is really important to the case, not only that, but any other in our country. So I have additional information, but if there are questions about that.
Thank you. Thank you so much. This is a very complex case. Only one, this problem of the language, no? In each question, there is this issue about the translation. One of the proposal is imposing the English as a kind of European language, or in the there is an interesting proposal to adopt a kind of a good automatic translation mechanism, no, a kind like a Google Translate or another, but a kind of official good system of translation. Because there is always this problem of the translation. For some countries it is difficult, no, for Lithuania, no, to find in Italy a translator in Lithuanish language. It is very difficult, no, for some countries is easy, but for other, so the solution can be or to accept English as a language in this case, in order to easier, or to have a very good system of automatic translation. There is no other, but there is always no, the problem is correct, this is not correct, this is one, it is in theory is the easy issue, but it is for each country is an issue. There is this also in the regulation, there is a rule about the problem of the ne bis in idem is a ground for refusal, the violation of the ne bis in idem principle. In the practice in Italy, we don't know this principle for confiscation, because in Italy, in the practice, we have to admit, it is always possible to say that there is another element of not suspect, but some other evidence of involvement in other, and it is always possible to reopen the case, at least in as a proceeding for confiscation preventive measure. There is always this, this issue. There is not only in Italy, because in some cases of the European Court of Human Rights, in the Todorov case, for example, the European Court stress these aspects. That is, and also in the Dimitrovi case against Romania, there is also this the European Court convicted Romania because there was this problem. It is not, the court says it is not possible open, reopen, no, always the same case against the same assets, no, for the same fact. So this is an issue in general about confiscation in national system of law. It is more complex when there is a cross-border case.
Hello, my name is Jose Company. I'm a senior prosecutor at the Central Unit for International Cooperation in the Prosecutor's Office in Spain. And I would like politely disagree with Dr. Marguerite. I don't think the case is a very complicated case. In the first part of the case in Sofia, there's not grounds for refusal. The thing of the women not to be convicted in Italy is not in the regulation. Then I don't think that the internal legislation of a country should prevail amount there.
The problem of the third party, because in this case it was a third party, no? The problem of the recognition of the rights of third party, because also in the regulation it is stressed the importance to protect the right of third party. And also in the judgment of the Court of Justice, in the application of the directive, there are some cases. For example, there is a recent case of 2021, Okras Vina Procuratura Varna. It is difficult.
It's not clear for the third parties, and we don't have case law of the European Court, if it's a matter for the issuing country or the executing country. If we are agreeing that's a matter for the issuing country and Italy say it's not third party, that's all. Bulgaria can go instead.
It is so clear that in the regulation there is, because in the regulation there is also that it is important that in the executing states each interested party, Article 33, each interested party has to be has the right to not a kind of a right of defense, no, the right to claim his rights.
If you allow me, I could tell you just to point out some issues from the court decision, which the final court decision. The court says, evident from the first verdict, the owner of the company does not appear as a first and last name in the court decision. So the Italian court does not convicted the woman which is owner of the Bulgarian company. Secondly, the issuing country has not specified facts about the companies that order bank transfers to that Bulgarian company. And finally, it cannot be concluded that this money were actually transferred to Bulgaria and that they are in a causal relationship with the actions of the defendants. So the court says that the content reflected in the certificate does not correspond the judgment which was.
But in that case, Bulgaria is retrialing the facts that Italy has considered, and it's not right according to the regulation. And just another little comment: the question of the translation, I think in some years, I don't know how many years, is going to be solved through the EEDS system. We are using the EEDS system for EIO. And now I write Hungarian perfectly. Then probably it's not going to be a problem anymore.
Yes, it's not a
couple of years or something.
No, the problem is the mutual trust also, no? So this is the please.
Sorry, if I may. Indeed, it's not for. Oh, sorry.
I had several remarks / questions about this case, because the first thing is the court in Bulgaria, at the end, comes to a refusal. But did they consult Italy before refusing the case? Because in my experience, Bulgarian courts often don't. And when you get a refusal, don't get a chance to give additional information that might lead to a recognition of the case. And after refusal, they state, no bis in idem, we can't redo the case. And then going into the ne bis in idem, it's not a question of a ne bis in idem. You have an irrevocable decision from another country. The only question asked to Bulgaria is execute this case for me, not to redo the case, convict this person again. So there is no ne bis in idem. It's still the same decision from the other member state. And it's only a new request to reconsider. So if I sent you a certificate requesting the execution of a confiscation order and the information is not clear and Bulgaria comes to a refusal, okay, I make a new certificate, I give more information, being more clear in my request, then it's still the same case. It's a new certificate. The only question that lies before the court in Bulgaria is, please execute this irrevocable decision for me. Not decide again if this confiscation order is okay, if this person is convicted and never send the correct grounds or whatsoever, because that procedure has been closed in the issuing member state. So again, that part of the Bulgarian law, I simply don't understand it.
May I? No. In listening to these difficulties coming from Bulgaria, of course, I'm thinking that probably going back to a very old idea, collecting all these difficulties across the 27 countries first, distinguishing difficulties which are related to single country or difficulties which are common to more than one country, which is a completely different things. I think it could be extremely useful to produce in the next few years, using the results of this project and new projects, that will build a manual for prosecutors, ARO and others. But much more than a manual is a platform with a dashboard, which will be increasing automatically according to the implementation of the regulation, where you include the legislation referred, difficulties in police and judicial cooperation. That could be extremely useful to police or ARO in a single country. When they have a request, they just type the country to whom they are requesting, and they have in the screen automatically. This could be done. We do in Transcrime for many different. It automatically come in the screen the main problems which are related to the single country to whom they are making the request, or to the country which is requesting. This could be the idea if the Ministry of Justice wants to fund this project, but this would be extremely useful. Probably the School of Magistratura could fund these kind of things. And I think it's extremely useful to send this idea to the European Commission, because this will be a very useful instrument. If this project produces as output listing typology of difficulty, the second step could be automatically having this operational manual that could be a fantastic instrument to make it much more efficient and reducing the gaps between countries, one with the other for the future. So thanks a lot for conveying this idea to my mind, because I'm thinking on the future, why we are doing this project, for doing what. To be extremely useful, the Commission is working to be useful to the police, to the ARO, to the state, member state. And this will be a way in which you can be extremely useful to these. I know that Amalia Orsira will have a second project on these things, but this could be a good idea to convey. What do you think about it, Mara Maria? To the DG, through the Italian government, we can send this message to DG Justice. And Amalia, you can continue for the next 5 years to write emails, but it's okay. But this could be extremely useful. I don't know what is the opinion of my colleagues, but it's a practical instrument.
Yes, sure. I suppose that in this case, the problem was also that it was a non-conviction based confiscation. Yeah.
Yeah.
Well, in this type of confiscation, the preventive confiscation, we only know the non-conviction based confiscation, special, extended, and the preventive. It's not our legislation. And when we ask Eurojust, we received some information, but it wasn't enough. And the judge, Maya didn't understood the situation. I think about a manual and about a program, it need to be a page about preventive confiscation to be clear for all the states what it means, because it is something else, I think.
And I should add that if a judge do not understand the situation, he refuses.
Yes.
But may I?
Yeah.
Yeah, just like in a few words, you have to know that the preventative confiscation has been deemed as totally consistent with the European human rights, the European Convention on Human Rights by the European Court of Human Rights several times. We are talking about still about convictions, not current conviction, but underlying conviction. So we are talking about a preventative measures applied when some crimes have been committed in the past to some particular categories of persons, and when there are, generally talking, of course, unexplained health that can be either explained as to its sources by the defendant. I want to also add, and this is something which I will focus on during my presentation tomorrow, that Minister of Justice, Italian Minister of Justice issued right after the enter into force of the regulation, a circular. And among the other things in this circular, we have pointed out for our authorities that due to some lack of provisions in the regulation, there is a kind of, the regulation, of course, does contain provision for both the confiscation, the direct confiscation, and also the no conviction-based confiscation. And we had several proofs about that because there are also specific provisions strictly related to no conviction-based confiscation. Among the others, for example, what Professor Moggeri was saying about guarantees and about bis in idem about guarantees, because there are a specific rule which relate to guarantees with regard to the so-called proceedings in criminal matters as distinguished from the criminal proceedings. In that sense, the European legislator is, of course, clearly referring to the no conviction-based confiscation, because this is also the origin of that provision. Throughout the negotiation for this regulation, that wording was put
Yes.
that on purpose to make sure also the preventative confiscation would be falling into the scope. But getting back to our circular, we've also written down something which our authorities are called on to put into the certificate, and I strongly hope they do. I'm confident they do, actually. But anyway, I will show you tomorrow, and this is kind of like summarizing of what the preventative confiscation measure is, to whom people can be applied, on which grounds. Yeah, and it's very useful, and I mean, I have already hit in English, actually. So of course, you will find it. But apart from that, we have to say that along with the approval, we can call it from the the European Court of Human Rights, we have to consider that the regulation is tailored also on this kind of measures. So here there is space mainly to ask for clarification. There is room for clarification for previous consultations, and I'm pretty sure that our authorities also, with the help of our circular, can just in case give the executing authorities all the information they ask for.
Okay, thank you so much. Now we have two options, or coffee break, or we carry on until the end without break. Would you like to do coffee break?
Middle option, like a short coffee.
Short coffee break. Okay, a short coffee break. No, it's okay. No, Matteo, where we?
Perfectly okay.
Okay.
I will guide you.
Però non c'è. Minutes. Now, I give the floor to Anna Sakellakari. Sì, okay. From the Humboldt University of Berlin. Please.
Thank you everybody. It's nice to meet you again. For those that we don't know each other, I'm Anna Sakellakari. I'm coming from Greece. Basically, this is the difficult name, and I'm representing Germany from the Humboldt. So Professor Martin Heger is where we are working together, but he could not make it today. So I'm here to represent Germany, and I don't have good news. I think I already told you last time that it's really hard in Germany because we're coming from the academia. So to find some hard cases. We sent several requests, and this is what I will present you today, how it happens, how it's working, the whole system in Germany from the answers that we got till now. And after, for the last minutes, I will present you maybe a hard case from Cyprus, because it's something that it was really interesting that for from the non-members, non-partners of the project. So there it was a nice hard case, but I will shortly present because it's not our hard case, but maybe interesting for you. After realizing that the latest official statistic of the prosecutor's offices, and from now on I will call it a prosecutor statistic, in Germany published on the 30th of August, so this August 2023, and covering the reporting year 2022, does not include any relevant statistical data at federal level in Germany concerning the application of the regulation, but just data on the freezing and confiscation cases at national level. We sent several requests, and I will tell you which offices. So first we have two German arrows, the police arrow in the Federal Criminal Police Office, so the so-called, maybe you know it, BKA in Wiesbaden, and the judicial arrow in the Federal Office of Justice in Bonn, and this is the Division on Extradition, Enforcement and Mutual Assistance, European Judicial Network in Criminal Matters contact point. So their answer was common and coordinated from the judicial arrow, which we also invited to the meeting today, but they could not make it because they had another Arrow Network meeting. So the second, it was responsible for the publication. So it was the Statistic Authority responsible for the publication of this prosecutor statistic. And this is in the same Department of Statistics in the Federal Office of Justice in Bonn, but another division. This is for awarding research projects, judicial statistics and criminology and so on. And there we had some answers, and I will present you in a while. The third contact point were the general prosecutor's offices in each federal state. In Germany, we have 16. So we just contacted the specialized asset recovery departments that they have in some of these federal states. And these are in Baden-Württemberg, Bayern, Berlin, Hessen, Niedersachsen, and Nordrhein-Westfalen. There we got just an answer from Bayern, from München, and from the General Prosecutor Office in Celle. So we see that it's really difficult for us to, and also we contacted the permanent representation of the Federal Republic of Germany in the EU, and we don't get any answer yet because we wanted to understand if they are the right office to send these, according to the Article 35 of the regulation, to send all these statistics from Germany to the Commission. And we found out after an answer of the Federal Office of Justice that the responsible office in Germany is the Ministry of Justice. So not the Arrow, not any other office, but they have, according to their knowledge, no data, no statistical data, although they are responsible according to the 35, the Ministry of Justice, they told us so. So from the answers, what are the things that we can share with you? First, it appears that both German arrows, the police and the judicial arrow, do not collect such statistical data. The answer we got from the judicial arrow, it was that the requested statistical data cannot be collected in that unit where just the individual ad hoc case processing takes place. So due to, because they mentioned that there is the direct communication according to mutual legal assistance between the judicial authorities of the EU member states. So they just have the responsibility to take over just in individual cases. And the second answer, it was that according to the information from the Federal Statistical Office, the federal states' statistical offices, so the statistical offices in each one of these federal states have submitted such data, but at a federal level, they could not be they could not be meant as reliable or usable. So the implementation of a new survey, and this is really important, they mentioned, requires organizational adjustments and changes in the IT procedures of the courts and the public prosecutors' offices in Germany. And it can be assumed, and this was also really important, that the collection practice in the federal states is not yet, and they mentioned this word, well rehearsed. So they don't have experience from having all this statistical collection in the federal states in Germany. And our assumption from the answers we got, it was that they keep the data basically manually, and there is no uniform system at national level. And this can be seen as a systematic problem stemming from the federal system in place in Germany. So another answer was that maybe this is also important for our project, that in order to collect these data for the regulation, the corresponding standardized federal statistical regulation has to be adapted. So they mentioned that we have to adapt the regulation, so a legal change, so to say, in Germany. So to change this federal statistical regulation, and at an administrative level, also make some IT applications specialized in the federal states, and training of the data collection centers there. So after, if everything would be done, maybe we will have better results. These were some of the answers. And I will tell you what we got from Lower Saxony and Bayern, like answers. So in Lower Saxony, it was also not particularly encouraging, the answer. According to their reply, they do not have centrally recorded data, but information, so they don't, the only information that they collect is the one asked from this prosecutor statistic. And this statistic, as we mentioned before, is not asking for any data from the regulation. So we see that they conform just with the statistic, and the statistic does not have any specific table that it's having any data for this regulation. So they mentioned also two other things. They said that this authority mentioned the inconsistency in the registration practices. That is not a new finding. And they are in a vague sense, they said that the different legal systems of the member states, the different legal traditions, make it difficult to implement the regulation in individual cases. This was something that they didn't give us any other explication. Italian interesting results is from Bayern, from München. So from the time that we have the regulation, the responsible office, asset recovery office in Bavaria, that is responsible just for the incoming confiscation orders, recorded 4 of them. And they were coming mainly from Slovenia, Austria, and Croatia. They were, most of them, for value confiscation. They do not have statistical data on which types of crime, and they do not have statistical data for how many were refused. So they just have a statistical record of these 4 incoming, already recognized confiscation orders. And just to know, maybe the practitioners here already know it, but you mentioned already the problem with the translations. In Germany, there is already a declaration that they accept the documents just in German. And basically, they do not ask for a copy or original, for an original freezing or confiscation order or a copy of it. But in Bavaria, the prosecutor mentioned to us that in some cases they ask for it, so out of the record. And this was exactly what we have from Germany. And I will remind you just the problems that we have, other 3 problems. It's that we don't have a central register for some assets like real estate, boats, yachts, pleasure boats, and so on. So central register is missing because we already mentioned it today. Real estate, as Professor Maugeri already mentioned, it is organized by property, not by name of the owner. So it's not easy to find out who owns the property, and lack of evidence on the beneficiaries of criminal assets. So these were 3 problems that we already mentioned, and they were extremely problematic. There is a best practice case that we basically find out just as a case, and I will mention it. Maybe you have already knowledge the REG case that Eurojust would, yeah. So you may confirm it or say something more. So it was an example that it was also in the press on May 2023. Namely, we have Germany's close cooperation with Europol and Eurojust, as well as with other member states and third-party countries, Belgium, Italy, France, Portugal, Slovenia, Spain, Romania, Brazil, and Panama. It was a successful anti-mafia operation. And among other things, it was also several companies that have been seized in the context of this large-scale operation. But yeah, this is something that we don't have more details from some practitioner. So I'm passing to the hard case from Cyprus now, because it maybe has to bring us something for the today meeting. So in Cyprus, I already interviewed the Arrow there, Miss Antoniou Kirmizi there, and the responsible Arrow is called MOCAS, and they have a dual role. It's an FIU and Arrow on the same time, and their competence, it's really interesting because there they have the Anglo-Saxon mixed system, so they have not exactly this mutual cooperation where the prosecutors are really cooperating between them, but the Arrow is interfering, and it has the competence to apply to the court and register and enforce foreign freezing and confiscation orders, either on the basis of the MLA or of the regulation of 2018. So it's not automatically done by the prosecution, and there is the need for a domestic order, domestic Cypriotic, so to say, order to register and authorize the execution of the relevant foreign requests. So there we had the case that it deals with two accounts identified in Cyprus and proceeds that derived from an internet fraud in 4 or 5 member states. It was Spain, France, Austria, Germany, and Slovenia. From Slovenia is pending, and it was about a very big amount of money that was traced in Cyprus. And there they have these MOCAS has their the opportunity and the power to basically communicate with the banks and just postpone any kind of transactions in the meanwhile. So kind of an urgent freezing. And they gave such instructions to the financial institutions who were given to postpone any transactions, and all the counterparts, all FIUs from the other member states were also informed, as well. Also, they mentioned also the persons affected. So after we see that it's an interesting case because we have companies that hold to account now they were under liquidation. And meanwhile, MOC has registered as a solution all freezing orders and waits to see if maybe they told us that they sent also a request to Europol and it's pending. They don't have any answer yet because maybe the solution which would be they register, as I said, the freezing orders, but they wait to see if some member state may not manage to get a confiscation order. Or another solution would be a joint prosecution under the Eurojust cooperation and coordination that could take place, or a member state could take over, not all of them, the whole case. So the liquidator is also in contact with the prosecution authorities of all member states involved, and this was basically a good case because they mentioned that it should be an amendment, in this case done in the regulation or in the certificate, for cases of multiple freezing confiscation requests. So the problem it was that they didn't know which kind of freezing or confiscation order from which member state should come as a priority, which they should enforce as a first one. So it would be interesting if you have any such case, or you could say something if you also found such problems, because the result would be that it would have a kind of first come, first served. So they wanted to know which rank they will follow in order that all member states will have the assets recovered, not just one of them. And exactly, this mentioned as one of amendment. They mentioned several amendments, but maybe now it's not the time to say it. So this was basically the hard case from Cyprus. And yeah, I think I will leave it like it is. So yeah, bad news from Germany, but good news from Cyprus. This is also an important thing. They had also another case, her case, that they also dealt with a case of freezing requests sent from Austria related to cryptocurrencies that they were identified in Cyprus, and this is about to get registered this week. So we are in contact with her. If you want to see something more about the cryptocurrencies and how it's working in the practice, it's a case that they have already. So it's interesting to see it. But she couldn't tell me anything more because it's a really actual case. So these are the news from Germany / Cyprus. Thank you.
Thank you so much, Anna. Are there some question, in particular about the complex case? Yes.
Maybe I can add a
Yes.
couple of ideas about the German.
Present you.
What?
Present yourself.
Yeah, Till Battle's my name for those who don't know me. I'm a member of the advisory board, and I'm a criminal judge in Germany. And I've done my PhD about the Italian confiscation law, and also the question of mutual recognition of the diverse forms of confiscation, and that's why I'm a little bit into this material. What I can say about the things that you just explained about the German situation is that I would confirm that it's that there's a lack of awareness for this special material of confiscation. In Germany, we have had a reform of the legislation in this material in 2017, which is aimed to enlarge the possibilities of confiscation. And so maybe with this, the awareness will come and will set itself through to the competent authorities, which are in charge then of the decisions. And what's to say? I agree. From what I know, I would agree to what you explained, that there's a lack of specialization in this field. That it's something that the local courts and prosecutors are dealing with kind of by themselves. Maybe Eurojust is a very good tool for optimizing cases that have connections with other countries, and cross-border confiscation is needed. So I think this is a really helpful tool for the German legal environment or law enforcement environment, so to speak. What I think is really interesting, what the prosecutor from Bari said, that there has been a case involving Germany too, and it would have been interesting to know on what legal basis they actually had their apparently successful corporations. Because if when I got him right, he said that it was on the basis of the confisca di disproporzione. So it's an instrument that's rather uncommon for the German environment, and that would be something to do more research about. If maybe some German court accepted this special tool of confiscation, and it has just not been published, because it would be interesting, definitely interesting for other cases of cross-border confiscation.
Unexplained wealth.
Yeah, exactly. Yeah, which is something that we have, by the way, in our new legislation, but apparently nothing that has really become a practical issue yet, or nothing that has been written a lot about. No big cases of big wealth that is being confiscated so far, but the tools are there, I would say.
The Selbstständigenordnung against the Selbstständigenordnung.
Die selbstständige erweiterte Einziehung. So.
Yeah.
Das,
in the sector of the fight against organized crime and terrorism. Yeah, but it is not clear until now if it is adopted in a criminal proceeding with the rule of,
it's clear.
is it clear?
It's criminal.
But in the opinion of Michael Kickling, the standard, when I spoke with you and Professor N, okay, is a criminal proceeding with the rule of the criminal. In the opinion of Michael Kickling, in another research, which was organized by the university, the Polish University of Poznan. The opinion of Michael Kickling was that this new instrument is more a kind of a non-conviction based confiscation with a lower standard of the proof. And so this is the real reason of its success in the application, the practice.
Should I start?
Yeah.
Oh, you can say.
Well, there is this new tool that has been implied, integrated in the German confiscation law, but so far it is not clear if the courts that have to apply it really do agree that it sets a new lower standard of proof regarding the illicit background of the goods. And I would think that at least the federal criminal court, the BGH, at some point will decide that there will still have to be reached rather high burden of proof, just how it has been in the past with the enlarged confiscation that already existed. Yeah.
Basically, we are speaking about the 76A4 of the criminal German criminal code, in order that we all understand it. So this is theoretically concepted in Germany, that is the non-conviction based confiscation form, because we discussed it also before. So theoretically, the new proposal of the directive would come under the Article 16, so the unexplained wealth confiscation. And the thing is that in the political level, they want to reverse the burden of proof. So they said in the coalitionsvertrag, in the coalition,
in the contribution contract,
that they wanted to do a reversal of the burden proof. But after came also Martin Jäger, it was against it with a clear mention in all the criminal professors said that such a thing is not accepted in Germany, as we rule everything in our criminal code. They say, I mean, I don't know, Michael, maybe means that we have these facilitators. We have some facilitators, indicators how to minimize, have a Beweiserleichterung, to minimize the what we ask as facilitation of the proof. Let's say indicators to facilitate the proof, and this is accepted. This is also applied from the German courts, and we have cases now. I presented in the last presentation, so it's really applied, this article. It's not that we don't have cases. We don't have cases. We don't know from these statistics which are the one that they were on the basis of the regulation. So I think that just the discussion was that if in Germany we think that in the doctrine we think that it's a civil nature, after we can also minimize the standards. But the thing is that if we have it ruled with criminal proceedings and in the criminal law, it's something that we say it's difficult to go outside of this scope.
It's very interesting because as Italy with other 5 European countries, Netherlands, Belgium, Spain, France, and what's the other one? We are part of the Germany, of course. We are part of the coalition, the so-called coalition against organized crime. It's an initiative launched by the Dutch colleagues. And among the other with an action plans made up of 11 measures. The Italian delegation, which is composed of Minister of Interior and Minister of Justice, is actually leading the sixth measure, which deals with the contrast to illicit assets. And as Minister of Justice, we are taking care of kind of promoting the confiscation measures, and among those, of course, the no conviction-based confiscation. And we actually gathered the kind of enthusiasm from all the other countries. We have already countries which have been implementing these kind of measures, but as maybe you just said, on different level. For example, France in civil proceedings, Germany with all these ongoing discussions. But we gathered, and also the Ministry of the Dutch Ministry of Law and Security, upon launching this initiative last October, was very proactive and also ready to gather our input on this field, which is actually something we have been developing all throughout these years. And just to make a little comment, unaspending wealth is just a part of the whole framework, because you have to get people who are suspect to have committed serious crimes on the one hand, or who have been convicted already for other crimes, still serious crimes, and belonging to a particular categories of crimes, or on the other hand, people who are suspected upon serious elements to live with the proceeds of crimes. So this is in Italy, just the backgrounds. But most important thing is that the trial, even though with maybe lesser safeguards, is still a judicial proceeding with judges, prosecutors, lawyers, and all we have been saying.
And also the Italian legislator called criminal proceeding in the law for the implementation of the framework decision 783 of 2006 about mutual recognition. Okay. It is also interesting the issue of the cryptocurrency. One of the proposal is introduce the harmonized rule on how to order obtain information from electronic money institution. This is as crypto asset service providers. So there is this proposal to introduce a kind of European passport. So a kind of license in one a specific European passport, in order to say that is a serious company, no, for crypto assets. And another proposal, but I suppose that is from Netherlands, but I am not sure that is introduce the possibility of a soft freeze, hardened freezing measure to enable the temporary and the quick freezing of assets prior to issuing a formal freezing order. This is also in relation to the problem of crypto asset service. I would like to ask if it is consistent with the rule of law, no? Because this is a kind of freezing measure in order to avoid that the money disappeared and so on. But in the end, in any case, the judicial authority has to authorize, no? Also after, yes, but yes, okay, so this is a compromise, no? You have a very quick instruments, but in any case, in the end, it is always necessary.
Yes, with especially with the new MiCA regulation from Europe, where the crypto providers can get a license in one EU member state and then offer their services within the whole European Union, it will become more difficult for us to get access to this information on the crypto assets and the transactions, and also to freeze those crypto assets. So one of the things from the from the Netherlands are promoting is that there should be become a EU regulation on direct contact between the national law enforcement authorities and those crypto providers that are located in another member state. Similar to the e-evidence regulation and directive, there already is. And via that direct contact, you could request from those crypto providers to provide information on which person, which information they have on a crypto wallet they have provided, which how many assets are there in that wallet, and please hold those assets. And then you have the time to send a freezing order to the member state to request for the formal freezing of those cryptos. If you don't do that in that order, those cryptos will be gone by the time you have drafted your freezing order, translated it, transmitted it to the other country. They have to go through their recognition procedure, etc., etc. So too many time will have passed. In the cooperation with England, UK, we already had an informal practice like this with crypto providers that were located in UK. Because the UK requested from us, if we send a freezing order, they want to know that there are assets to be frozen. Otherwise, they don't want to go into the proceeding of freezing. So we had the bilateral agreement that it was okay for us to contact the crypto providers that were located in the UK to request them for information on the transactions and the assets in the crypto wallet. Those crypto providers often have the practice then that they will hold those assets because they know law enforcement will request for a freezing. Yes. And I think also for the crypto providers itself, it will be very useful if there was EU regulation on it, because then they have a legal basis to do it as well. Yes. Because that is now a difficulty in practice. And with outside of the bilateral agreements we have with the UK, we cannot just go and contact providers in all other member states because we don't have those agreements. And so we have to go via the formal authorities now, but that takes too long. So we need some new regulations on that.
Yes, true. Please.
I want to say that we have the same problem in Romania. I asked a provider which are the provision in which they can froze in a soft law the currencies until we will go with a freezing order. And they say that in the terms and condition from the beneficial when they create their account, they have that provision that if they are asked by national authorities, which are authentical or be trusted, to freeze for a limited period of time, they assume that and they accept that freezing, but is a civil provision, is not an international criminal cooperation. Now, but yes, it need to be done in this type of instrument at the national, at the European level.
But I think you said the magic word, and it was what I asked also in Cyprus in this time limit. So in the urgent freezing is really what you said with the rule of law. I mean, we are coming from the academia. We always have to say, because you will have a problem also like prosecutors when the defense lawyers will come and they will say, yes, but there was no time limit. And like in Cyprus, they have 30 working days for this urgent freezing that they are also these MOCAs really using in the praxis. But I think we should be in the regulation in a EU level, really like have a limit, because otherwise it would be a huge problem, I think, with all the rule of law
discussion.
It can be done with immediate measures. The 11 article from the new directive, in which RO can immediate freezing until a new freezing order on the regulation. But also that article, it was a problem for many states.
Netherlands, because Lithuania is not, yes, no, there is no representative of Lithuania. So Van Lise, no, Lise Van, no. Okay. And as legal advisor of the General Prosecutor Office, is correct? About. Thanks so much, in any case.
Yes. Okay, so I don't have one special hard case. I have several cases which illustrate elements of things, issues we encounter when cooperating with other member states under the regulation. And maybe I want to start my contribution by saying that the good thing from all these examples I'm going to give and the problems that are in there, the recognition part of the order was not the problem. They get recognized. Only the execution is a problem. So the good thing, the recognition, okay, that's the good part. One of the examples I have is from the cooperation with Spain. One of the things we often encounter is when we ask for freezing of bank accounts, we don't get a report back on which assets actually were frozen after execution of the freezing order. And then in many cases, we have to send an European investigation order to get the bank balance of the accounts that were frozen on basis of the European freezing order. And in our opinion, the regulation says in Article 7, paragraph 2, that the executing authority has to report back which assets are frozen and where available also the estimated value. And I understood from my colleague in Spain, who was working as a liaison magistrate officer there in Madrid, that the Spanish investigative courts have the possibility to simply see the information on bank balance via a system in Spain. So it's really problematic that we don't get this information and we have to send a special investigative order to Spain when the regulation gives the basis for Spain to give us that information after executing the freezing order. And we haven't gotten through this barrier that there seems to be in practice in Spain on this topic. Then another problem we encounter is when we request for the freezing of, this is also Spain. I'm not bad mouthing Spain, but sorry, this example is also from Spain. When we request for the freezing of immovable property houses, then we see in practice, the Spanish courts will recognize a European freezing order. They also will order to the property registers to actually freeze the assets. And then the property register often says, no can do, because I don't have this information. You didn't give me the correct information on this. It can be the person, the NEA number of the person, or the amount of the claim for which the freezing needs to be registered. Some information will be missing from the court decision to freeze those assets, and then the register says, "No, I don't enter this freezing in the system." We don't always get the information back. What was the problem? So in some cases, we have problems with communicating after the execution with the Spanish courts to find out which is the problem and how can we get this fixed in practice. In many cases, we have to send a new European freezing order. while the first one was already recognized and the court already decided he wanted that asset to be frozen, we have to send a new freezing order to get the registration in the correct way. And then we will try to add the information that was missing from the first court order to freeze these assets. And even sometimes after a second freezing order, it will still be no results from Spain. So it's a really difficult part. And then when we succeed to freeze those immovable property, these houses, in many cases, there will still be a period of 4 or 5 years. And after that period, the freezing will expire. So you have to renew for, yeah, well, actually, I had one case from, I think it was Javea, they said 5 years. So in practice, we also experience most times it's 4 years and we expect 4 years, but yeah, in 2022 we got a decision back. It would be for a period of 5 years. So it's okay. Then we get an extra year. But the problem is then in practice, we don't get the information, not always get the information back that it was registered and that this period is running. So we don't always know when to renew the freezing. And even if we know the period and we send a new request for renewal of the freezing order, then in practice, the same problems with registration of the freezing order can encounter. So in many cases, the freezing is already, the property is lost. So we encounter a lot of problems in this respect. Then with the duration of the freezing order, we also encountered this with freezing of bank accounts in Lithuania, where we earlier this year sent a freezing order for a bank account. They froze the bank account for 6 months. Then we, after about 5 months, asked for a renewal of the period. And then again, we get a period of 6 months. Knowing that the confiscation procedures in the Netherlands can take many years, especially when they appeal and also go to a court in higher instance, it can be more than 5 or 6, or sometimes in complicated cases, 10 years before the case will become irrevocable. Dus if you have to renew the freezing every 6 months, that is really a burden. That is so. I think that the thing that we have to think about renewing it while we already sent an European freezing order, stating that we need this asset to be frozen until we have a confiscation order that we can send to the other member state. We shouldn't be obliged to renew it. If for me, it's okay if the national law has these periods, but then in my opinion, part of the asset management procedure in the executing member states should be that they automatically renew it as long as this freezing order is not withdrawn by us. So it should not be the issuing state that has to initiate the renewal of the freezing order. We already requested the freezing order and we stated in our certificate we want this freezing to last until we send an irrevocable confiscation order. As long as we don't withdraw that request, just execute it in that way. And if you have a period in your national law after which it needs to be renewed, fine by me, but it should not be me as the issuing authority that sends that request. Then I also have a case with Italy where we successfully requested for the freezing of 3 motorboats. It was in order to preserve the right for recovery in respect of an obligation to impose payment of a sum of money, like value confiscation. In the Netherlands, we would sell these boats because these boats will depreciate in value. So we requested Italy to for interlocutory sale of those motorboats. And that request was first refused. They wanted to have more information on the difficult word, depreciation of the value. So an expert on the valuation of boats from the Netherlands made a statement for the Italian authorities that states that boats will depreciate in value after time, and then if they're not being used and being stored somewhere, that will also have a bad influence on the value. And then the Italian court says, no, that's too general. That is not enough information. I cannot order the interlocutory sale of those boats based on this information. And what they need is to have exact value of the boats at the time of the seizure, the current value of the goods of the boats in which the depreciation is accounted for, and a calculation method is taken into account. And it needs to be specified on the boats that are actually frozen in Italy. And then considering that the boats are in Italy, it's virtually impossible for the Dutch authorities to provide this information to the Italian authorities. So that's a problem we run into. So as a consequence, in that case, we are now trying to look into possibilities to transfer the boats to the Netherlands, so then we could sell them in the Netherlands.
It was an interesting case. We interviewed the prosecutor of Genoa, and in a case where there was says the freezing order was from France on a very important yacht. The problem was how is it possible to manage this yacht? We have to also pay in order to guarantee the value and so on. So the solution was very practical. The prosecutor office of Genoa send the yacht to France, so it is a problem of France. It is maybe the very okay. There is some money to spend for the trip, but in the end, is the very easy solution.
Yeah, so that is the solution we're trying to look into now as well. But then I hope that we don't freeze too many boats in Italy, because then it will become as
the problem is that when there is a country without that is not on here, so
yeah. So these were the cases I gathered to illustrate some of the issues we run into.
Would you like to?
Yeah, one thing to add, the interlocutory sale of the boats is different in different countries. So the regulations are very different. In the Netherlands, we try to fix the value of the confiscated object as soon as possible by interlocutory sale. So that we're able to, both in the interest of the defense and in the interest of the issuing country, be able to preserve the value as much as possible. But we recognize that other countries have different methods. So the practical approach of, well, if it's not possible to sell the boats, then try to sail the boats to the Netherlands. It's a very practical solution, but it's not always the solution that would work when dealing with other types of confiscation goods where depreciation of value is inherent to that good. For instance, racehorses or something like that.
Because in Italy we have two problems. First of all, the idea is that we have to guarantee also the rights of third parties and so on. So if we sell, these rights, first of all. And secondly, we have a specific approach about the destination. The idea is that not only to guarantee the value, but normally the destination is for social use. So maybe we are less careful with the problem to preserve the value, but because the idea is that their use for social reason and so on, also for association, voluntary association, other. The idea is that the asset has to be used by the civil society, no? As a kind of compensation in the fight against organized crime and so economic crime. So yeah, it is an issue. Maybe it is in the new directive there is something more, no, about it, because there is this direction in the directive that is when it is possible, it is the easy solution. Yeah, please.
You can also correct me after. For the interlocutory sales, there is a provision in the new proposal, but I wanted just to ask two things in the points that you mentioned. I mean, of course, maybe a solution would be to send the boats, but you didn't think about like sending like maybe. I understand that the problem maybe sometimes is that the executing authority needs so much time and money to do all these calculations, and maybe they are not willing to cooperate in this sense. So except of the things that of the social use, maybe it's also a practical thing that they don't want to spend time and people, that staff working with this case. So you didn't think of sending like a representative of the Netherlands in Italy to make such a thing, or could be maybe a possible scenario that you have a representative of the issuing state, an expert that is doing these calculations in your office, sent as an expert there where the assets are, so in Italy in this case, and just do the work that the Italian authorities should have done, or how to motivate, I mean, the execution.
Yeah, well, actually, we would have to hire such an expert because it's not a requirement in the Dutch interlocutory sale procedure to have such a detailed information. The general information that in general boats will depreciate in value when they are frozen and stored is enough for the interlocutory sale in the Netherlands. So we don't need to have this specialized evaluation of the boat that is frozen. What was the value of at the moment of freezing? And even if you are several years later doing this discussion with the Italian authorities, we can never go back in time and evaluate a boat at the moment in history. And then to motivate in that valuation decision as well, what the exact depreciation of value of that exact boat is also not a requirement in a Dutch procedure. So we don't have Dutch colleagues doing these valuations in our practice.
Okay, and the second point would be of the pleading you have here. You ask for that you don't, as an issuing state, you don't send always renewing freezing things. And the question would be, but the renewed freezing order has always also new information inside. So how the affected person would be informed if, I mean, it's just an automatic thing that this I didn't understand how to be conform with the information of the affected party if you just do it in an automatic way that the first freezing order is just exists and not a renew, that it would.
Well, actually, there's one freezing order. You send a freezing order, you request for the freezing. If you ask for renewal, you will send, in most cases, a letter stating that on such and such date you sent an European freezing order to that and that member state. That date the asset was frozen. That there is a certain period of time has expired. Then you have to renew it. Then you give some information that the procedure in the Netherlands is still ongoing and that you still want to have that freezing order in force. And hope that they will cooperate in renewing then the period of the freezing. But actually, on the basis of the regulation prescribes that the freezing should stay in place until a confiscation order has been transmitted. So such time periods that are in national law are not in line with the regulation. And my personal opinion is I don't mind if national laws have these time periods. It's okay. But then it should be the executing state making sure that the freezing will stay in place until the issuing authority says, now it's enough. We don't need it anymore. Or now we have our confiscation order. We'll send it to you so you can execute the confiscation order. So I don't have problems with these national legislation where such periods are determined, but my statement is that it's for the member states who have these periods in their national law. It's their responsibility under the asset management to make sure that they renew the freezing until the issuing authority says we don't need the freezing anymore.
Yeah, thank you for your contribution. Just one comment that fits to your topic and as well to the Bulgarian topic of problems, not recognition of the freezing orders and confiscation orders. And I think what we have to keep in mind is that mutual trust is a good thing, and it's in the books, and it's also partly in the heads of practitioners. But to convince a foreign authority to set your freezing and confiscation order in practice, one should try to make the statements as accurate, as complete as possible, and they should be even more self-explaining as they are in the national jurisdiction, I think, because it's obvious that the trust in a national context between the authorities is higher than when it comes to cross-border collaboration. And maybe one more thing that also fits in this topic is often I think it's lack of communication. What you said, for instance, with the prolongation of the freezing orders, this could be something that is resolved on a rather practical level just by mere communication, no? Saying, okay, we have this timeline here. Please give us some more information by telephone, and then they can give information, can say, okay, the reasons subsist. There's nothing to add, and we want the confiscation order to be kept in practice, and then this should work. So communication would be another important issue, I think.
Yes, I agree exactly with what you were saying. Just out of curiosity, in a domestic Dutch proceeding, what is there a need to renew a freezing order? No.
There is
This
thing is about to explain a bit more and reacting to the comment the German colleague just made. There is, of course, when dealing with interlocutory sale, a provision under Dutch law that the defendant can ask a judge to revoke the decision that the prosecutor's office wants to make. And the defense always has a possibility as well to, for instance, pay a sum of money as a guarantee that the specific object will not be sold. So there are rights to the defense that are in domestic law very well protected. So it would help as well, not just to be specific on exactly what we want as issuing state for the executing state, but as well the explanation to go with that the defense has options on the national law to comment on the decisions made by the prosecutor's office. And usually, in my experience, it would help to spread that knowledge so that a judge in an executing state is informed well enough on the merits of the case, including the possibility of the defense to make a point on the interlocutory sale in a different state.
But I think that is also a problem of guarantee of safeguards, no? Because a freezing order without a temporal limit is a kind of confiscation without a judicial order. This is not possible, no? Because, okay, we are speaking of assets, but if you can not
But this will never be without a formal decision to confiscate, because you can only keep the freezing in place as long as the procedure is still ongoing. If there is no procedure for confiscation, then there is no grounds to freeze the asset anymore. Then you have to lift the freezing, and during the freezing, the person concerned also has the possibility to object to the continuation of the freezing, and then a court will assess if there's still a reasonable ground to keep it in place.
Okay.
So they have the
Yeah, because also in the regulation, no, there is a rule that it is necessary that the confiscation order has to be the freezing order is not specified as a temporal limit, but it's specified that it has to be as quickly as possible, something so, no? Because there is also a problem, no, to guarantee the owner.
Yeah, so there are safeguards in the Netherlands. They don't only have in the beginning of the freezing the possibility to object to the freezing, but after a period of time, if the situation in the case has changed and they think there is no reasonable ground anymore to keep the freezing in place, they can again appeal, object to the freezing, and the court will assess it again.
And there's also, apart from specifically on the freezing, if a procedure is, for instance, if we were to have a period of inactivity and nothing happens at the prosecutor's office, the defense has the right to appeal to a judge and say, well, judge, declare the case ended.
Yes.
And then all the measures will expire.
Okay.
So there are provisions, but it requires an active approach on the defense if the material provisions are met beforehand by the prosecutor's office.
Very quickly.
I think if now that we see that this is a system, I for example, from the several systems that I know, I did not know of this system whereby there's not a need under the domestic level, let alone cross-border, to renew. Perhaps a good practice would be that in the freezing certificate, in the additional information, you could add that under your law there is guarantees for the suspect.
Yeah.
And that would maybe suffice sufficient for the executing authority not to ask you. It may be.
Yeah.
If that shows already, that may work as you cooperate more and more with a given country and practice is established. I don't know. It may well be. I'm just saying, if this type of dialogue and that they are satisfied or not, that the rights of the defense, let's say, are ensured in this way, that they can at any time challenge that decision.
Okay. Thank you so much. Now we don't have a lot of time. So Poland, Minister of Justice, I don't remember, sorry, the name.
Mr. Szymański, Minister of Justice, I will be very kissed because I must apologize to you because we cannot prepare any hard cases. While I'm filling our questionnaire, we identified some cases that could be a such case. However, we do not get the quality information from the authorities to present them here. As I said on our online meeting, it is extremely difficult to get cooperation with the Ministry of Justice and the relevant authorities. Maybe it will change now because of the changes in Poland. So maybe on the next meeting, I will have something more for you, like a more practical, because, you know, I am not a practitioner. I'm just making a law and that's what I do. So maybe next time. I'm sorry.
Thank you so much. Don't worry. Now, Romania. So we have a set recovery office, and in particular, we have Eduard Gabriel Levai and Alice Scutarau Sandro, something so.
Yes. Alice Scutaro Sandru
Yeah.
and Eduard Levai. My colleague is an expert in our asset management and recovery office. It's an expert and inspector in management of the assets, in interlocutory sales, and also in cryptocurrencies. I'm a judge, a civil judge, but I'm seconded in the Asset Recovery Office for 3 years. I'm really glad to be here and to make a link between regulation and the new directive. It is very important to understand that this instrument need to be common, to take in a common way. And unfortunately, I was at every expert meeting in Brussels on this directive and the negotiation. I know very well each of article, and I can say also what with the colleagues from Holland, we have the same problem. It's not as much ambitious as it will be needed. But that's we have it now. It's in trilogue at the European Parliament. About hard cases, we will present 3 hard cases very briefly. 2 cases about recognition and 1 case is about the execution. First case I already presented in the last meeting. It's a case with France. The National Court from Romania partially recognized the confiscation order. In fact, to the confiscation order issued by the Judicial Court from Paris, several assets belonging to a Romanian citizen were confiscated, including a property acquired in 2010 in Romania. The French authorities went through the procedure to recognize order according to the regulation. In Romania, the file was registered at the Cluj court. The security measure of extent confiscation, as you know, is highly repressive. Since it is a security measure, it is subject to more favorable criminal law provision. In the case law of the Romanian Constitutional Court, it has been established that the provisions relating to extent confiscation are constitutional insofar as extended confiscation does not apply to property acquired before the entry into force of the law which regulate the extent confiscation. So the law 63 was regulated the extent confiscation in 2000 and next slide in 2012. In this context, the Romanian court from Cluj did not recognize the extended confiscation order by the French court in relation to the real estate that was purchased in 2010. In conclusion, I think it is the same for a lot of Eastern European countries, which they are not were not familiar with extended confiscation until 2010, something like that. In conclusion, in Romania, extended confiscation orders of asset acquired before the date 22 April 2012 cannot be recognized. Indeed, we don't have a provision in the regulation as we can refuse to recognize for a constitutional principle. It is not very well.
No, there is Article 8 F and
immunity.
Yeah.
Yes.
No, not immunity. There is one of the ground of refusal is when there is a serious breach of fundamental rights.
Yes, you can go on that, or you can go about immunity because it is an immunity if you can't confiscate that asset. But I also agree in that.
It is in this interpretation means that there is no mutual recognition, no mutual trust. Because if you say I don't have this instrument, so I don't apply your instrument, this is the refusal of a mutual recognition, mutual trust. Sorry. If I speak about a breach of fundamental rights, I have to say something that is not based only I don't have this instrument, but because in this specific case, the application of the instrument means also a violation of a fundamental rights, for example, the right of defense and so on. But in the specific case, but if you say I don't have this instrument, so I don't apply, in France was recognized also before the regulation a preventive confiscation measure because the Supreme Court, the French Supreme Court said, Crisafulli case, I don't have confiscation without conviction, but there is the Strasbourg Convention of 1990, and also in French, is possible to confiscate the proceeding of a money laundering. They have the confiscation like punishment, the general confiscation against money laundering. So if I demand the same legislation, there is no cooperation. This is the Supreme Court, the French Supreme Court. So
I think I agree with you, but I think it's a problem, and maybe a question to the European Justice Court may have a opinion.
Justice Court said that it is not. There is a case that it was about not the directive, but was about the framework decision of 2012, and said it is not necessary that they have the same instrument because
Yes, indeed, but it's about a law. Now we have, if we have a constitutional court decision, it's at the same level as the constitutional power. So we will have a fight between the constitutional act with the regulation in this matter. It was the only case. I think I appreciate that it's a correct solution. Maybe other states, maybe issuing states will consider that is not correct. But like when you have a criminal, you need to be double criminal in each country. Is the same principle as in this matter of confiscation. If I don't have the confiscation, this type of confiscation at the moment.
The principle of retroactivity. Yes, this is you can say fundamental rights, the principle of retroactivity.
Yes, but fundamental rights, but in every case, it will be in every case. We will see. Maybe in another case, the European Court will be asked about this fight between laws.
But if I may, I think it would be interesting, and I think it might be an obligation for the Romanian court to ask that question as well, because in my opinion, that rule of Romania that extended confiscation orders cannot be made if the asset is acquired before the date of April 2012 only applies in the territory of assets in the territory of Romania, because this regulation is not in the issuing state, and the perpetrator has made his decision to put assets in another member state or even commit crimes in another member state. So the rules in the decision on conviction and confiscation, the rules of the issuing state apply and not of Romania. So, and even in the recognition, you cannot check those questions. So please let the courts ask this question to the European Court.
What means to recognize an order? It means that the order will be the same effect as in Romania, Romanian order.
Yes, but mutual recognition
I don't have it in Romania for that point, that year.
But mutual recognition sometimes means that you execute something that you would not have as a type of decision if you made it nationally. But it can be for criminal offenses.
If I don't have that criminal...
No, but if it's for a criminal offense, and that falls within the list of offenses in the regulation. And it is a fact that in Romania is not a criminal offense, but in France it is. Then you have to recognize it, even though you wouldn't be able to convict a person for that fact in Romania. So why would you not be obliged to recognize the confiscation order in this type of situation? I don't understand.
In the next case, I will ask
Please.
judge to
Please do.
to ask
Please
the
do.
European Court. I am aware about that. Even if I have my opinion, which is minority here, I understand it very well. Because if I was the Romanian state as issuing order, it can be some. I will be grumpy about that if other state will invoke something like that. But yes, sorry. The second case is with Austria. Sometimes it is difficult to identify precisely the persons who may have an interest in relation to the assets subject to the confiscation order. That's the summary. In fact, the confiscation order issued by Austria was recognized and an apartment from Romania was confiscating. According to the land register and the sales contract, the apartment belonging to the convict person. In the procedure for the forced execution of the order, the ex-wife of the convicted person, who did not participate in the procedure of issuing and recognized the confiscation order, submitted an appeal to the execution by which she requests the judicial division, citing the fact that she is a co-owner of the apartment. The ex-wife proved that, although she was not mentioned in the land register nor in the sales contract, at the time of the purchase of the apartment, she was married to the person targeted by the confiscation order. According to Romanian civil law, assets acquired during marriage are presumed to be jointly acquired by both spouses, even if only one of two spouses is mentioned in the contract of sale. The civil court found that apartment is a joint property, establishing the share of participation of each of the ex-husbands at 50% assigned to apartment to the wife, with her obligation to pay the enforcement bodies the equivalent of the 50% share that belonged to her ex-husband. Even though it may seem like a disadvantage situation for Austria, it should be noted that the value considered by the civil court was that of the market at that point. Thus, it is very likely that in the event of a foreclosure of the apartment through a public auction, the amount obtained will still have been approximately 50% at the same value. In conclusion, it is very important that the courts that are invested with recognition of confiscation order make all the necessary checks to identify all persons who could subsequently justify a right of or an interest in relation to the asset that is subject of confiscation. The court didn't know about the wife. No one didn't know about the wife. She appeared after, and that was the solution. It is an ethic one, problematic in the procedure, but it's ethic, I think. And the third case, and I will close with another case with a friend, is no example. It's not good example. A Romanian court admitted in part the recognition of the confiscation order issued by a French court, the refusal being based on a provision of Article 19. The National Court reanalyzed on the basis of the evidence administered in the case that certain sum of money cannot be subject to extent confiscation. The person concerned convicted in phrase for several acts of qualified thief, providing a proper lawful origin of these sums, is like the same case like in Bulgaria. Yes, and also affect the mutual trust between states because defined at Article 33. And that's, I think that's it, the three cases. One last mention, maybe in this case, in the third case, the prosecutor didn't appeal the sentences, and the sentences it's fine now. Maybe it can be imagined the right of the state, of the issuing state, to have the power to appeal such sentences when they see that it's not, they are wrongly, totally wrong. We don't have in the regulation. Maybe as a new proposal will come to make such a new provision, because it was a wrong sentences. The friends cannot attack their sentence, and it is a problem. Thank you.
Thank you so much. So now Spain, José Miguel Company Catalá, yes, senior prosecutor, senior Spanish public prosecutor, working. Okay. See you tomorrow. Working in Madrid as deputy to the Supreme Court prosecutor on international cooperation. Thank you so much.
Anyhow, journalist from the Netherlands has stolen my thunder. Then, if you don't want to listen, there's no problem. Okay, I'll be short. The first case is a case with Lithuania, but it's not a single problem for Lithuania. In fact, Lithuania makes everything good, and was our system the problem for the case. As you can see, the facts is that criminals from Lithuania convince German citizens to invest in a real estate project in Malaga, a fake one, of course, and they transfer 1.3 million to accounts in Spain, Greece, and Hungary. On March 2021, Lithuanian intelligence agency notifies to the Spanish one the operation, and the Spanish Financial Intelligence Unit also communicates to the PPO in the Audiencia Nacional. Audiencia Nacional is the central court for specialized crime, organized crime, anti-corruption, and terrorism. That due to the Lithuanian notification, they have requested the bank for the immediate suspension. This arises the first problem. In Spain, we have this very weird situation. The Financial Intelligence Unit can suspend freeze the bank account without any kind of order from no one for 1 month, but we prosecutors can do nothing. We cannot make a call to the bank and say, please, nothing. Then it's kind of weird situation. Then the prosecutor in the Audiencia Nacional contacts Vilnius Public Prosecutor Office, and the same day, Vilnius Public Prosecutor Office issues the certificate. We have this management cases systems in the Public Prosecutor Office called the CRIS, and then immediately that the prosecutors in Audiencia Nacional put the case into the system, arrives to the Malaga Public Prosecutor Office, who is the competent in the case. 3 days after, Malaga Prosecutor's Office submits the certificate to the on-duty investigating court. In Spain, are the investigating judges, the investigating courts, the competence for freeze assets And the law obliges to the prosecutor to also present a report. He did it. And apart from this, he talked personally to the judge, saying it's a very urgent case. There are money in the account, and we have only 1 month until 8th of April. And then it's kind of a sad or comic situation, tragicomic. We have this. We have a internal Judiciary Council regulation about case distribution among the investigating courts that does not consider that the freezing orders are an urgent matter. That provokes that most of the judges, when receive one certificate, they send to a central office to distribute among the judges. Then we are losing time in this situation, a lot of time. Then what happened? The court, the investigating court, 9, executed the certificate on the 16th of April, but the suspension accorded by the financial unit ended on 8th of April. Then the funds were not in the account anymore, of course. Then, if you see the map of Spain, you can see a lot of little cells in the map. This is what we call partidos judiciales. It's kind of judicial competent areas, and we have almost 5,000. And then it's completely absurd that these people, these judges, are the competent authority to execute. You have to find who is. For the people from the other countries, it's impossible directly. Then it's one, if not the principal problem, or the principal problem that it's not a lack of volunteers, as the analyst said before. We probably do not refuse any kind of order. We are a very cooperative country, but in this kind of bureaucracy and stupid things, most of the orders are not really executed. Then, of course, this internal Judiciary Council has to be reformed. And I think the other two things are really important. In the 6th round of evaluation of the European Union, we were told as a country that we have too many authorities for international cooperation. Then politicians took note, and in 2018, we prosecutors became the only authority for receiving EIOs and for executing EIOs if they don't affect two fundamental rights. Then now, at 2023, the Public Prosecutor Office executes the 93% of the European investigation orders and receive all the orders. And in the other 7%, we present in front of a judge. Then the only solution for this dispersion with the certificate will be that we start to be also here in assess recovery, in this kind of certificates, the reception authority. And we should have, at least in urgent cases, of course, can be challenged in front of a judge over decision, but some little power of freezing bank accounts, because on the contrary, if the financial unit did it, it's okay. If not, we don't have any possibility. I spend my days at work calling or writing to colleagues from Europe saying, no, I cannot freeze, I cannot do everything. Please issue a certificate just today if you want to keep some of the money. Well, this will be the first case. The second case is a bit tricky because the case and the freeze was under the old legislation, but the sharing of the profits were under the regulation. I took here this case because it also arises the main problems apart from the ones that I just said for execution in Spain. I'll explain more tomorrow, but I want to mention them today. It's a case of corruption here in the PPO of Milan. We collaborate through some MLA with size assets. And finally, Italy in 2019, in the final judgment, declared that it should be confiscated 36 million euros. They say that regarding to specific assets, the confiscation should have the form or in order to pay an amount corresponding the value. Okay, then it was not a problem of this Italian petition where we can adopt it, but we have all the problems that Jan-Elise previously said. We depend on the real estate, on the register for execute these orders. If there's a mortgage on the house, we have also a problem with the legislation about mortgages. As I already said, we have problems with the competent courts for the confiscation. And now also we have this problem with the third parties in good faith. And also we have problems if the items are, the owner is a company, although even is most of the time a fake ownership, but we have also a problem with this. Then I appoint here, tomorrow I'll explain wider that we have to reform our procedural criminal code. We have to reform also our mortgage act. And we have to empower the PPO for these kind of things, or on the contrary, if the politicians doesn't want empowering us, is also a very frequent thing in Spain, a general lack of trust of the politicians to the prosecutor office. Other option would be specialized judges. It's not just for this question. In Spain, it's a very huge problem, the lack of specialization of the judges. The prosecutor office is specialized, and you can deal with a very complicated case of corruption or environmental crime or something, and the same judge that is passing a sentence for a robbery or a petty crime is deciding on these huge cases. Then there's no obviously there's not a very good system. Thank you. Yeah, I'm ready. I want to have dinner also. Yeah. No. I want dinner then.
Just a very quick thing. If you could sign the papers about data protection very quickly, you will find them also tomorrow. So very quickly.
Okay.
We're taking photos. But then we will go outside and have dinner. Finally.
Thank you so much. Sorry that we don't have more time for debate, but we have now we have a dinner, and it's also tomorrow. No, is it possible? It's possible also
tomorrow. Okay, perfect.
Yes.
Preferable now. Okay.
But it is sufficient to indicate your names and not have it in only names. Only names.